My lord, item number 1. My lord, lordships cannot take up these matters. While going through the records, we found the committee which appointed the appellant, lordships was there in the committee. Yesterday, my lord, because we took permission to go through the records, two, of course, very important aspects came to light. Of course, that is on the realm of merit. Now, my lord, I'll just indicate in the minutes of meeting dated 9/3/15, my lord, this decision was taken, my lord. Sorry, minutes of meeting dated 23/11/16, where Honorable Justice H. Roy, Ujjal Bhuyan and Lordship was the committee, where, my lord, the appellant was appointed as a protocol officer.
But is that under challenge, protocol officer?
No, but eventually that is continuing, my lord.
But that is not otherwise in effect.
No, my lord, why I'm making this submission? Lordships, it is a lordship's call. Now, what had happened prior to this, there was a meeting held on, my lord, 9/3/2015. That was a committee headed by Honorable Justice Vaipei, B.K. Sharma and C.R. Sharma. There, my lord, a decision was taken that for filling up the post of protocol officer, we should invite 5 candidates if there is 1 post. Now, that matter was debated. Eventually, my lord, a decision was taken based on the model adopted by the Kerala High Court. Whenever we make appointment of such nature, my lord, then these appointments will be coterminous. Assuming, my lord, somebody is appointed as an, my lord, private secretary. Now, he will not retain the post once, my lord, the incumbent who appointed him goes. So, those models were accepted. Eventually, my lord, that rider was added, whereby it was said why he will maintain seniority in this senior judicial, assistant. This was the reason, because they adopted the Kerala model. So these are the aspects which are never highlighted, neither in the affidavit nor in the course of the argument. Only when, my lord, we peruse the records, my lord, we could come across all this. So idea was, my lord, that is why his seniority was retained in senior judicial assistant. And now he has been appointed as protocol officer, will continue. The moment the incumbent who appoints him goes, he will revert. The idea was not to give permanency.
That's all right. That is on the merit
Of
of
merits,
the matter.
of course, merit. But here is a case, my lord, where lordship was a member of the committee.
Mr. Chamua, the problem is once Mr. Chaudhary has raised this issue.
My lord, in my respectful submission, they have not challenged the appointment
No,
of
this
protocol
is
officer.
for the judge concerned, not
My
for
lord.
the parties.
My lord.
Our duty is to point out, my lord, the decision lordships will take. Thereafter, others I can argue. There's no
They
problem.
shall not prejudice their interest because of the fact that lordship was a committee who was, when he was selected as a post of protocol officer. Here it is a challenge that how he is appointed as a secretary to chief justice.
No, the
He was
question
appointed-
is,
he was
question is
appointed by the
also
chief
propped
justice.
up, question is also propped up, whether he would be in senior judicial assistant or he would be treated as in the feather category. That is the
That
issue.
was a
That is the issue which boils down. Anyway, my lord, I felt it's my duty to point out.
No, if the proceeding hinges upon his appointment, the validity of his appointment as protocol officer,
Certainly, my lord. The reason being,
then we'll not take
the
up.
reason being, my lord,
it
we
cannot
will-
be.
no,
When
my
it's
lord,
not under challenge.
High Court's lawyer will be fair. It's not a question of one case, my lord. It's a question of fairness in the system. Now, lordship will see, our contention is he continues to be in senior judicial assistant. That issue has cropped up in the course of hearing, my lord. Now, that is why lordship the other day asked a question. If somebody becomes assistant executive engineer, how can his seniority maintain in the
Well, that's
assistant
unfortunate
executive? No.
because of our, no.
No question. No, you'll make your submission. I'm not coming in the way. My submission is, my lord, here is a case since the issue which is involved is whether he continues to be in the senior judicial assistant. Therefore, my lord, I'm just pointing out your lordships.
Mr. Nair, since he has raised this issue,
Hmm.
let the fairness, let justice be seen to be done.
Hmm.
upon the-
I'm ready to argue, my lord. If any issue comes up, I'm bound
No,
to
no,
reply.
it's not
my lord.
about arguing. He's saying this bench should not take up that matter because
Yes.
I was a part of that committee which recommended his
My
appointment.
lord, that issue was never raised. The protocol officer was never in question. Then how can it all of a sudden, just to, my lord, derail the whole process, my lord, take a plea like that? And my lord would see what was written in the order.
Let us see the.
My lord would see the impugn order.
No, my lord, then my lord, let us proceed on one basis. Then my lord, that he is in still in, though he was appointed as protocol officer, he continues to be in the senior judicial assistant. Let my learned friend accept that, I have no problem.
Why should I?
Why should I?
My lord will come to page 58.
Take down. Heard Mr. UK Nair, Learned Senior Counsel, assisted by Mr. So appearing for the writ appellant. Also heard Mr. K. M. Chaudhary, Learned Senior Counsel, appearing for the respondents to caveators. When these matters were taken up for consideration today, Mr. Chaudhary has pointed out that one of us, namely put my name, was a party to the committee which had recommended the appointment of the private respondent, namely Sri Nirod Sharma, to the post of protocol officer. First of, since the validity of the appointment of Sri Nirod Sharma in the post of protocol officer is also an issue which would arise for consideration of this court on the judicial side. Hence, submits Mr. Chaudhary. In order to maintain fairness in the proceeding, it may not be proper for this bench to take up the matter. Full stop. Since learned senior counsel for one of the parties has raised this issue, this court is of the opinion that it will not be proper for us to continue with the hearing of this matter. Full stop. In view of the above, let these appeals be listed before any other without one of us bracket my name. After obtaining the necessary approval of the Honorable Chief Justice on the administrative side.
My lord has said, my lord is not taking up, but this is never an issue and this never will be an issue.
My lord,
sorry,
my learned friend should
sorry,
appreciate one aspect of the matter, my lord. That is very much an issue. Whether he still continues to be in the senior judicial assistant.
Mr. Nair, supposing nothing is an issue, if one of the parties says.
I
this bench should not-
understand that,
Is it
that's.
fair on the part
No,
of
no,
the
my
bench
lord,
to
my
proceed?
lord has taken that view. I have nothing.
What
But
will
that
happen to the
plea,
judgment
no,
tomorrow?
but that plea that has been taken, my lord, it's not proper. That's what I want.
That we can't say.
No,
My
no,
lord,
my
but
learned friend.
the
is
action-
nobody to- My
No, no,
learned
my
friend
lord,
is
the action
nobody
of your
to pass
lordship.
judgment
I
whether it's
understand.
proper or
Understand.
improper. It's I have done something which is consistently followed in this court.
We cannot comment on these things, Mr. Nair. We are only concerned that the faith of the litigants.
Understand. To that extent, I'm not.
Fairness of the judiciary should be maintained at
That much.
all cost. Even if there is a whiff of
My lord.
doubt.
And that is how things are done.
But this side also, my lord, we should be very careful of what we are saying.
That
No,
you
no,
need
of
to-
course,
you need
of
to
course, I
introspect.
know, but anyway,
There is no restraint from this court on introspection on that. You
no,
are
my lord,
free to,
no, my lord, I failed, sorry,
Much
I'm
obliged.
just taking 1 minute time of yours. Now, my lord, is it not an issue eventually which will boil down to that whether this gentleman respondent number 5 appellant, he continues to be in the cadre of senior judicial assistant? That's a question which has already cropped up. In that view of the matter, would it be a proper, my lord? That is what I'm thinking. But it is, I have only pointed out, I've never said that lordship should recuse from the matter. All that I said is, since your lordship was a member of the committee which recommended this, and also said that he will maintain his seniority in the so and so.
that's all right. The
Yes.
order has been dictated.
That's the only thing.
But the idea of pointing out is
Yes,
so that there is an element of
yes,
participation. already.
right. Because my
So-
lord, because that is very much an issue. Now, if that issue remains for adjudication, how my learned friend can ask your lordships to take up the matter, my lord? That's the
No.
point.
I am nobody to.
Nothing happens on who asks.
Who
what.
asks or
It
not.
is a question of our own conscience.
Yes.
So we we go a step further to maintain the purity of the stream of
Lordship,
justice.
lordship.
And that is what is
most
expected.
important.
That is
Who
what is
wins, who
expected.
loses is
Yes,
not the
yes.
issue.
Yes.
Whether such an issue should be raised in the bar, we leave it to the bar.
I only want
No,
to
my
say
lord, no, my
that.
lord.
Much obliged.
Let us also make one thing very clear, my lord. It's not a question of we want lordships to recuse from the case. What we have done is something. This is the practice which is being followed in this court. That is what I have said, nothing else.
All right, all right. So any other matter in the
Matter, my lord, actually, Recruitment was suspended, my lord, and suspended, my lord. And my lord, we filed an affidavit on the effect of the suspension, my lord, from when he was, notice was handed over, my lord. And they filed, my lord, reply, my lord.
22nd?
22nd, my lord, that week I am not here, my lord. So,
Then you have to wait. 19 rejected.
no, my lord.
Any other day after 19?
Yes, my lord, and 31st, my lord,
All right,
31st.
all right.
Lordship, in item number 2, we have filed an affidavit in reply yesterday. That is not on record. That may be called for lordship. In item number 2.
Yes.
Item number 2, Lordship, we are directed to produce the records, Lordship. May I pray for 1 week's time, Lordship?
No, my lord, there was no such direction, my lord.
Wait, let the matter be
Let the
called.
matter be called.
Made this lordship. Item number 12 of today's list, my lord. Due to some, I'm led by Mr. I. Chaudhary, my lord. Due to some sudden, well, urgent work, he had to leave out of station, my lord. Can it be taken up, my lord, next week, my lord?
No, we'll adjourn it for 2 weeks.
My lord.
On the prayer of learned counsel for the writ petitioner, hearing of this matter stands adjourned for 2 weeks.
Obliged, deeply.
May please, I beg to mention on listing I, my lord, regarding the stay vacating, my lord.
Regarding?
Stay vacating, my lord.
Ah.
Your lordship matter was hard and it was fixed, my lord, 8/5/2020, but that day, your lordship now matter was listed another one, that was left over, my lord. And we are praying for vacating the stay.
Next week,
Date 22.
24.
May it please your lordship. Lordship, I beg to mention an item for listing tomorrow, my lord. A writ petition regarding transfer matter, my lord. Transfer order was passed on 9th of May. And we have filed a petition on 11th of May, my lord. It has not been listed. If possible, my lord, tomorrow. Obliged, my lord.
Lordship, I beg to mention an item for listing. In this matter, Lordship, 47 lakhs were deducted from pensionary dues, and this matter last came on 3/2/2023. So it is possible matter may be taken up.
First week of June,
But
put a date.
a date may be fixed.
You fix the date.
All,
Yes.
and there is another matter for list.
Again, first week of June.
Obliged.
Paying for listing of metal lordship. It was last listing at December, January 2022 was.
Yes,
Next week was.
sorry, what?
It was last listed on January 2022.
Second week of June. Yes.
May I please, your lordship? Lordship, I'm praying for listing of an IA on 13th May, lordship. Main writ petition is fixed on 13th May, lordship.
13th May.
May.
We are already on 16th May.
30th May.
Or 30, yes.
Please, your lordship, I beg to mention about listing the matter. Lordship, petitioner is working as a nursing tutor in Well India Limited. And there was an advertisement for permanent post and petitioner was applied, but her age was over for 1 year. And again, she was applied, gone to Chief General Manager, and he has given a letter to enhance the age. But HR and Human Resources and Acquisition did not consider for that. Your lordship, in on 18th, lordship.
18th of June.
Lordship, scrutiny is going on, lordship.
Ah.
With short, lordship.
What scrutiny is going on?
Advert for that admit card for the exam.
When is the exam?
Exam is date has been not finalized, lordship, but scrutiny is going on that admit card will be issued, lordship.
No, 18th May is not possible. 24th May.
Is lordship. Obviously.
May please your lordship. Lordship, I beg to mention item number 6 of today's list, lordship.
Yes.
Matter may kindly be adjourned, lordship. It may be taken up next week, lordship.
This is along with item 5.
Yes.
Item 5, my lord, at the instance of official respondent, both the matters were taken together and the item 5 was from urgency, my lord.
Then let it be called up, then we'll see.
As for instruction of the petitioner, my lord, the petitioner may be allowed to, my lord, withdraw the petition with liberty to file a case.
Mr. K. Sinha, learned counsel for the writ petition, submits that he has instructions to withdraw this writ petition with liberty to file a fresh. None has appeared for the respondents to oppose the prayer. In view of the above, the prayer made by the petitioner's counsel stands allowed. His writ petition stands disposed of on withdrawal with liberty as split for. Obliged.
Order stay vacated item 18.
May it please your lordship. My learned senior has given me opportunity to argue before your lordship today. My lord, the hearing IA, it amounts to hearing entire matter. If I pray your lordship and we hear the entire matter and dispose it off, that will be my lord. Because I have
Where is the order?
that
You are seeking a vacating of a stay order. Where is the order? Which order? Which page?
in IA,
In I.
11. Page number 11.
Page number 11. And
So what is your client is from which cadre?
Assam Meghalaya cadre. I have prepared my list of dates. It will be convenient to
He is in the police service.
police
Yes,
service.
sir.
He is an IPS 2005 officer, my lord, and joined Assam and Meghalaya cadre in 2006.
So where is he posted now?
Now he is on deputation in Competition Commission as my lord, additional director general, Competition Commission. He was appointed on 29 2021.
29.
2021.
The period of deputation is for how long?
For 3 years, 2 years completed, but in the order of appointment, it is that prior to that also he may be.
Now, what is the prayer in the writ petition?
In the writ petition, prayer is made, my lord, while my lord considering my prayer for deputation, they have not considered the policy decision taken by Government of India, where your lordship weightage and my lord priority should be given to the officer who served in Northeast for the period of 10 years. For that, taking into account that this honorable court directed them to produce record. What is the mechanism they have adopted in giving weightage priority? But in nothing has been produced, my lord. In the affidavit, they have simply said they have taken into consideration that policy decision, but no records, nothing, my lord, to show that they have in fact taken.
So one post of additional director in enforcement is still vacant.
Yes, ma'am.
And so why don't you consider his application afresh in the light of the policy and pass appropriate orders?
My lord,
Otherwise,
Yes.
this matter has to be heard. These are only two options available.
yes, ma'am.
Final hearing, have you got the records?
Yes, ma'am. I don't have now, but I'll bring the record, my lord.
Bring it then,
Yes, ma'am.
because if the consideration is not found to be proper, the only order the court will pass is for a fresh consideration, that's all.
That
Why don't you do it in any case?
Yes, my lord.
Why don't you do it?
My lord, because we have already filed that affidavit in opposition also.
All
in
right,
policy,
then the
my
matter
lord.
will take time. Wait, not now.
My lord, then, my lord, then date may be in the next week. I'll produce the record also.
Not next week.
My lord, because of the stay order, my lord, that's why.
That's why I'm giving you a easy exit. You are not taking it. So much of ego.
No, that is not. Actually,
Reconsider his case in the light of the policy decision
my
and
lord-
reject it.
yes, my lord, because they have joined already in the other department, other
Or-
ministry.
Heard Mr. A. Goyal, learned counsel for the no, Ms. A. Goyal, learned CGC appearing for the applicant. Also heard Mr. A. Goyal, learned counsel appearing for the OP read petitioner. This IA has been filed with a prayer to vacate the interim order dated 18/11/2020 passed by the learned single judge in WPC number 4881 of 2020. Directing the respondents not to fill up one vacancy in the cadre of additional director of enforcement in the Directorate of Enforcement till the returnable date. The interim order was thereafter extended by this court. Full stop. The writ petitioner belongs to the Assam Meghalaya cadre of the Indian Police Service and at present is posted as additional DG in the Competition Commission of India at New Delhi, in which post he is serving on deputation. Full stop. The grievance of the petitioner is that his application for deputation posting in the Directorate of Enforcement was not considered by keeping in mind the policy decisions of the Government of India pertaining to the officers posted in the Northeast. First up, on a pointed query made by this court as to whether the authorities are willing to reconsider the application of the petitioner in the light of the policy framed by the Government of India and pass a fresh order, the learned CGC has declined to carry out the said exercise. Under the circumstances, this court is left with no option but to finally decide the writ petition. In view of the above, let this writ petition be listed for final hearing on 5th of June 2023 as a fixed item. On the next date fixed, the learned departmental counsel to produce the records. It is made clear that in view of the urgency expressed by the respondents, no prayer for adjournment will be entertained on the next date fixed.
Can it be after 5th, my lord?
No, it cannot be.
6, my lord. 6 or 7, my lord.
Why? What is the
I
problem?
shall be out of the session, my lord.
6th.
6, my lord.
My lord, instead of CGC, my lord, that may be stated as a SCED, my lord. ED.
SCED, yes.
Must have.
6. Deeply obliged.
Daily list for admission item 1, partner.
Interim order passed earlier to continue till then.
May I pray, my lord? My lord, this matter, item number 1, my lord. This matter is led by my senior counsel B. Kaushik. Due to some unfortunate and due to some unexpected reason, he could not be present here in Guwahati today. Therefore, my lord, I pray slight accommodation only for the day, my lord.
My lord, this case was substantially heard and your lordship directed us to submit the written argument with a point to be clarified me today only as to how and what will happen if no approval is granted, whether a subsequent application is maintained. So if your lordship pleases, then it can be taken up on Thursday.
No, it cannot be taken up.
Or I may conclude my argument and we'll submit our written arguments, my lord.
30th May.
My lord, I am for the workman and he has already retired and he is not getting any pension. He is not
So,
getting.
Mr. Chakravarti, what is sad is, don't be the client before the court. You are an officer of the court.
My lord.
Your colleague is seeking accommodation due to some personal difficulty. Come up and say that you oppose the prayer. We'll record it and proceed. Don't speak like the client. We can't hear the client on all this. Clients will always have urgency. So we expect counsels to be different from the client.
Exactly, my lord. But
so you are talking like the client.
My lord, it is a part-heard matter.
All right. You have objection, we'll record and we'll proceed with it. Yes. Ms. So-and-so, learned counsel for the petitioner, sought accommodation in this case for today only on the ground that her senior is unavailable due to some personal reasons. However, the prayer has been opposed by Mr. S. Chakraborty, learned counsel for the respondent. Respondent number
1.
Respondent number 2.
Respondent number 2. Under the
5.
circumstances, this court is left with no option but to proceed with the hearing of the matter.
5, my lord, I'm respondent number 5.
Respondent number 5. Yes, Argu. But these are setting very bad precedents in the bar.
My lord,
Very, very bad precedents in the bar. You all should discuss these things before. And why are you throwing the ball to the court? One counsel seeking adjournment, another counsel having urgency.
my lord, yesterday he called me up and the understanding was that he will be submitting the written arguments.
Proceed.
And he is in Itanagar, my lord, for some matter. My lord, on the last occasion, lordship wanted to know whether the application for approval, if not taken, can be taken subsequently. Lordship may have a look at the judgment on the other day I had given, my lord. 2003 1 SCC 320. In this case, the similar situation arose. First, an approval was sought for, but it was rejected by the tribunal on the ground that 33(2)(b) was not complied with. Now, subsequently, they filed another application, complying with the approval, complying with the proviso. Then it was allowed. Then matter was challenged in the High Court. Single judge allowed dismissed the writ petition. However, it was allowed by the division bench, and then matter went to Apex Court. Apex Court said that once you file an application for approval and it is rejected, then you cannot file another application. For that, you have to once again comply with the provision, pay the wages, then you can file. Now, here it is a case, my lord, where the man has already gone on retirement on 31st of December 2021. So at this stage, a fresh dismissal order cannot be passed against him. Lordship may have a look at the judgment. First, the background, my lord. The judgment and order dated 5/6/98 of the division bench of Karnataka High Court in writ appeal number so-and-so are under challenge in these appeals. In the written submissions filed on behalf of the petition, it is stated so-and-so has left the service of the petition company and hence this SLP. The respondent workmen were in the service of the petitioner company. They were kept under suspension from so-and-so since an industrial dispute was already pending. The company moved an application seeking approval of the order of dismissal dated 21/1/86 of the respondent under 33(2)(b). The National Industrial Tribunal, by two separate orders, both dated 1/9/87, held that the orders of dismissal were invalid for non-compliance of the provisions of 33(2)(b) of the Act. In that, wages for 1 month were not paid. These orders of the tribunal remained unchallenged and attained finality. The petitioner stating the non-compliance with the 33(2)(b) as mere technical breach passed orders of dismissal for the second time on 9/10/87 without any further fresh inquiry and without paying wages to the respondent for the period from the date of the first dismissal order dated 21/8/96 to 9/10/87. That is the second order of dismissal under the order. Now, my lord, the approval was granted, considering that the second application is in order, relying on a judgment of Punjab beverages cases. Then matter went to Apex Court, and my lord, I'll just take your lordship to the final part, paragraph 9. Having not challenged
the earlier order dated 1/9/87, it was not open to the petitioners to make a second application seeking approval for the order of dismissal of the respondent. That too without paying full wages. The division bench of the High Court has found that the second order of the dismissal amounted to unfair labor practice and victimization. The tribunal was not justified in allowing the second application seeking approval by ignoring the dismissal of the earlier application made by the management for non-compliance with the mandatory provisions of law. The tribunal proceeded on the ground that the earlier application was not decided on merit and held that it was open to the petitioners to file a second application. This is clearly contrary to the decisions of the Constitution bench. It appears to us that the petitioners designed to defeat the claim of the respondents by making a second application when the order suffered by them on the first application had become final. Even as stated in the decision of so and so, the petitioner failed to pay full wages to the respondent between the period of two dismissal so and so. So, my lord, what I have understood from this judgment, that if you dismiss or remove a person during pendency of a reference case, then you have to file an application for approval under 33(2)(b). If you file an application and it is rejected, then my lord, the order will have no effect because the dismissal will be subject to approval. But if you do not file any application or file an application and withdraw it, then the order will remain inoperative and void ab initio. Now, you cannot correct the second by filing a separate application subsequently. In that case, you have to take a fresh decision, comply with the provision of 33(2)(b), and then take a decision. Here in this case, my lord, the petitioner has gone on retirement on 31/12/2021. And the removal order was passed sometime in February 2018. From 18 to 21, he should be deemed to be in service in view of the constitutional bench judgment because they have not filed any application for approval. You have to pay the wages and then, but since he has retired, there cannot be a fresh order of dismissal or removal. So, my lord, this is what I thought your lordship wanted to know. As regards the other issues, I have prepared one written argument and I have given. I'm sorry, my lord, I'll give it within a few minutes because while coming, I could not get the printout. Another aspect, my lord, I'll be pointing out to your lordship about the delay. Now, what happened? This award was passed on 19/12/19. It was communicated to the management. It was communicated by the secretary to the labor department, by the assistant labor commissioner, as well as the respondent number 5. They have not challenged that award. My lord, for computation of wages under the award, one proceeding was filed under 33(c)(2). Notice was sent to the management. They did not file. To the understanding of the work respondent, the reason for not filing is if they challenge the award and a stay is granted, they will be required to pay him the wages under 17(b). That is a mandatory requirement. So, my lord, they have kept waiting till his retirement. This writ petition was filed after his retirement. So, my respectful submission before lordship is they, in spite of having knowledge of the award and the proceeding under 33(c)(2), they did not challenge because they wanted to bypass the provision of 17(b). Now, everything has been decided. By this writ petition, they want to turn the clock back. And if it is allowed, my lord, it will amount to rewarding the bank for their own wrong, deliberate wrong, because 17(b) is clear. If an award of reinstatement is passed, and if it is pending in the High Court by of an interim order because it is not implemented, then the workman will be entitled to wages under 17(b) from the date of the award. May I draw your lordships to the provision of 17(b)? where in any case a labor court, tribunal or national tribunal by its award directs reinstatement. Here is a case of reinstatement of any workman, and the employer prefers any proceeding against such award in a high court or the Supreme Court. The employer shall be liable to pay such workmen during the pendency of such proceeding in the High Court or the Supreme Court, full wages last drawn by him, inclusive of any maintenance allowance admissible to him under any rule, if the workman had not been employed in any establishment during such period and an affidavit by such workman had been filed to that effect in such court. So, my lord, what I have understood, if an award of reinstatement is challenged in the High Court during the pendency of the proceeding, the workman will be entitled to his last drawn wages, provided he is not gainfully employed. Here is a case where in the evidence before the labor court, the workman had categorically stated he is not gainfully employed after his removal. Now, had they approached the court earlier on getting the information, this was a mandatory requirement which they ought to have complied. To deny this, they have waited.
That you have already argued.
My lord. So and the other one, this technical, your lordship wanted to know about it, the technicalities, what will happen, I have already said. I'll give my written arguments, my lord, during the course of the day, within 10-15 minutes. And my lord, I pray that this writ petition may not be entertained. I'll give a written argument on all the points that I have argued earlier also and now.
My lord, because he has brought out some crucial points, we may be afforded an opportunity to reply, especially with regards to section 33. My lord, just one opportunity to reply to that, because it is very crucial for this.
When?
My lord, may give it on Thursday or any day next week also.
Right, 23rd. However, after hearing the submissions made by Mr. Chakraborty today, Mr. Chakraborty, Learned Counsel for the respondent number 5, this court is of the opinion that he has addressed the court on a new issue today, and therefore the respondent's counsel should be given an opportunity, therefore the petitioner's counsel should be given an opportunity to respond to such argument. In view of the above, let this matter be listed again on 23rd of May 2023 as a fixed parted matter.
Much obliged. My lord, there's an interim order that may be continuous.
Interim order passed and yet to continue.
Much obliged.
Item 2 and 3.
May I please also? Also 6052 is regarding also challenging the provisional gradation list. That is now not important because final gradation list has been published, and that is under challenge in 6236 of 2022. So lordship will take up the matter 6236. Lordship, I have joined the Water Resource Department as per advertisement made by the department for recruitment to the post of LDST. 5 number of posts were advertised. I am the general candidate. I am selected. I have been appointed. As per advertisement, lordship will find advertisement at page 30, dated 18/9/2010.
Page 30.
Page 30 is advertisement. We have type copy at page 29. That is on 18/9/2010. Post was 7 number of post, and I have selected for general category and I have been appointed. After completion of written test and typing test and everything else. Appointment at page 33 lots. I have joined as per office order dated 1/20/2010-11. Dated 19/2/2011. Page 33, Lordship. I am Samsundar Saha, Lordship. My joining report at page 34. I have joined on 21/2/2011. Now, Lordship, the private respondent was a workshop employee, and one notice was issued, not a recruitment process. One notice was issued, page 38. Page 38 is a notice to the workshop employee for recruitment of the post of LDS and issued by executive engineer. That notice was issued to the petition to the respondent here in Lordship. You'll find copy to Sukhendra. Sukhendra Narayan, Lordship. This advertisement said this notice was issued to Sukhendra Narayan for applying to post of LDS. Respondent note 5, Lordship. Last portion, Lordship, copy to Sukhendra Narayan. And Lordship will find it is a notice. This is not a recruitment process, this is a notice.
Who is Sukhendra Narayan Dhar?
He is a private respondent. Thereafter, Lordship, he was
And this is dated 7/3/1994.
94. My submission will be, Lordship, recruitment process is governed by the Assam Ministerial District Assembly Service Rule. There is no quota for workshop employee. Workshop employee who is not holding a permanent post or a post, they cannot be recruited by giving a notice to the post of LDS. That is why, Lordship, the Assam District Ministerial Assembly Service Rule says that on the basis of a advertisement issued to the all people available in at that relevant time, by making advertisement, public advertisement, recruitment process should be started. Direct recruitment.
So then from watchers Khalasi to junior assistant.
Junior assistant.
How did it happen?
How did it happen? That is, Lordship, ultimately, Lordship, the government of Assam has issued a notice. Lordship will find that will find, Lordship, at page 78, Lordship. That is starting from page 76. Page 76, Lordship. That is on the basis of a finance department notification. That is the inquiry report. The inquiry report submitted by the Civil Engineer Water Resources Department on the illegal promotion awarded and brought to a regular cadre person holding the personnel post under Water Resources Department, right later dated in 2016. Finally, Lordship will find finding at page 78. Page 78.
Yes.
From the above, it is clear that service of workers, master role workers of Water Resources Department who has engaged prior to 1493 and in continuation of service was regularized by creating ex-cadre post, which was personal to the incumbent concerned, holding the post of automatically abolished and relinquished of the post on whatsoever ground by later dated Iman. So such temporary creation of post cannot be automatically added to the cadre strength of department, and claim of promotion from a person holding ex-cadre post is not legally tenable. As such, their promotion and bringing them to the regular cadre without any prior approval or order is illegal and liable to be reverted back. Lordship, this order has been passed on 28 August 2017.
So this is regularization in the as work charge or masteral worker, not as junior assistant.
He was encountered to the junior assistant from workers employee. There is no recruitment rule do not provide that workers employee can be recruited to the LD assistant by a notice.
But as per the records, this respondent number 5 was
Works employee.
appointed or recruited or whatever it is as a junior assistant when?
Junior is then on after this advertised notice given to him, he was recruited as a LD assistant. Page 40. Lordship will find page 39 type copy. In the interest of public service, Sukhendra and Dhar, Chaudhary Department works as Khalasi, is temporarily appointed as section assistant, lower division assistant from the date of joining. Page 39 is type copy. Lordship.
And when was he regularized in the post of
Thereafter, Lordship will
LD
find
assistant?
his page 44 and his service book. I have typed out the Lordship, the type copy as page 44. In the interest of public service, in a continuation of the office memorandum, Iman, the service of Sukhendra and Chaudhary Khalasi hereby extended temporarily until further orders. Iman, is that Iman? Service transferred to the regular establishment of LDA from the date of joining is Silchar. Page 44, Lordship.
Then was he regularized in the post of LDA? Mr. Chakraborty, was
Yes,
where is the order of regularization?
My lord, for that I'll have to trouble your lordship with the IA. In that I haven't.
Okay, then you sit down.
2001.
Then you take your seat. Let us see.
Now, Lordship, on the basis of this order passed by the chief engineer, as Lordship will find, the person working in the water resource department who has been promoted to the LD assistant has been reverted back. Lordship will find page 88 also. Page 89 is the Lordship, the one of the Lordship.
Yes.
Page 88. In compliance of the secretary's order, the executive engineer, water resource Karimganj has reverted back. Subhasis Day, page 88, Lordship. Subhasis Das, hereby reverted back to his original post. Type copy, Lordship will find annexure 27. Page 87, Lordship.
No, but what has happened to another candidate? We are not concerned here.
Lordship, thereafter, Lordship, the provisional graduation list of the water resource department has been published. After knowing all these facts, I file objection that he is also appointed from Khalasi to the post of LD assistant and thereafter promoted to the PUD assistant. So he cannot be considered as a senior to me in the cadre of, and the second position, he has given the first position. I have said.
That's why I'm asking the relevant particulars. You are jumping into inference. That inference is yours. You can make a submission. But first give the facts.
Lordship.
When did the private respondent become LDA? When did your client become
Lordship.
LDA? Where are the list of dates? Where are the notes?
Lordship, I'm giving the. I'll give a list of dates, Lordship. I have not. Lordship, I have been appointed, Lordship, I have already stated that I have joined as a LDA assistant as per recruitment process on, Lordship, 19/2/2000. 19/2/2011.
So yours was direct appointment in the post
Direct.
of LDA.
LDA.
And what about respondent number 5?
Respondent number 5 is a works as employee. And notice was given to him and some other employees personally.
Page 40 is his first appointment as LDA, is it?
Lordship.
That is of the date is
93/94.
7394, madam.
73/94.
Then he was continued and then finally regularized in a order which is in the IA, which will not go into right now. Which IA? What is the number of the IA?
My lord, the IA for vacating of the interim order, that in that my your lordship will kindly see. I have
The
enclosed
IA must be having a number.
my lord, 644, my lord.
Yes.
There your lordship will 540. 540.
Page number?
Page 22, your lordship will kindly take up first. My lord has got page number 22, which is the type copy. There your lordship will see, these are the incumbents who were regularized in the post of LDA. As per Deputy Secretary to the Government of Assam Finance Department, Guwahati, so and so, after completed 5 years of continuous service under a regular establishment, the following senior most lower division assistants are hereby provincially confirmed with effect from 1/6/2001 in the scale of pay as admissible under, and respondent number 9 and respondent number 5's name appears at serial number 5 in that list, man.
So regularization is with effect from 1/6/2001.
Exactly, man.
That is prior to the petitioner.
Man.
Is this order under challenge?
No. They
This
have,
order under
no,
challenge?
this has not been challenged.
We are not against that he should be terminated or he reverted back. We are challenging that in the final gradation list published by the Water Resources Department, he cannot over me.
No, that is your argument. That your argument may or may not be accepted, but I am asking a question of fact. Has the regularization of the respondent number 5 in the post of LDA with effect from 1/6/2001 been challenged or not? That's what I'm
No.
asking. It has not been challenged. Therefore, this order will have to remain.
No,
This
sir.
order cannot be interfered.
No,
with.
sir.
All right.
I-
Yes. Mr. Goswami, service matter. Very,
Lordship,
very
I understand,
technical.
I understand also. I have already-
Your impression,
I have
interpretation.
already informed my clients to challenge that also. But that cannot be challenged because of the lordship case was immediately vacating application has been filed. Thereafter, we get the regulation order. Thereafter, I have suggested, but we could not challenge the regulation.
That is okay. Court is not asking for a
Lordship,
explanation.
no, lordship is not asking lordship. I just suggested my client.
Yes.
Now lordship will find this house.
So in a nutshell, your case is that although the respondent number 5 was appointed as an LDA and regularized in the post of LDA prior to appointment of your client, yet since he was directly inducted from the post of Khalasi, therefore this process was reversible in the sense that he could not have been promoted to the post of LDA or appointed to the post of LDA. Similarly situated persons who were earlier recruited or appointed as Khalasi
Has been reverted back.
and regularized against ex-cadre post were reverted back. So he should have been reverted back. But all right, if he has not reverted back, that is fine. He cannot get seniority over you.
Over me. Because works as employee, there is no reservation for works as employee in the LD post. LD post, as per Assam Ministerial Service rule, the works as employee cannot be, there is no quota.
No, but Mr. Goswami, these aspects cannot be gone into. You have not questioned his appointment and regularization.
We have questioned also. We have challenged his initial appointment.
Where is, have you asked for setting aside this order? 7/8/2001. Is this order under challenge?
That's it.
In which writ petition?
In prayer portion also will find.
Is it under challenge, Mr.
That's
Chakraborty?
it.
These are simple statements of
Appointment
facts. Let
letter
there be-
dated, appointment letter dated 17/94 issued in favor of the respondent by executive engineer shall not be set as a clause. We have challenged his appointment.
By filing a writ petition 2022.
Lordship.
And what about the order of regularization?
Order of regulation. I have been affected in recently when this seniority list has been published of the EDSN. So I have challenged the order of EDSN, in the gradation list of EDSN, where he has been shown above me. And after knowing the fact that already some person who has been recruited from the WhatsApp employee has been reverted
Mr.
back.
Goswami, I have understood. You are heavily banking on only one thing, that some other people have been reverted back. But if that argument fails, you have nothing else.
Lordship,
That you agree?
understand.
So only thing is we'll see whether that argument has any validity. If not, you don't have a case. You agree that? You agree to that?
Lordship,
All right.
we have stated in our paragraph in the petition that initial recruitment process is illegal against the appointment rules. Assam, the Ministerial District Service rule has not been followed. So his illegal appointment cannot count seniority indicator of EDU.
And what is the challenge in WBC 60?
Provisional gradation list.
Provisional gradation list. Let us see where is the provisional gradation list.
6052/2023.
So first you filed 6052. Then after that you filed the second this writ petition. Which page is the provisional gradation list? Page number? Page number?
Lordship. 54. Page 50, Lordship.
50.
50. He is Lordship 1, I am 2. 51, Lordship. Right.
What is your date of retirement?
My date of retirement Lordship will find. My date of birth is 74, he is 68.
So he will retire much earlier than you.
He will retire not much earlier, is 4 years, 6 years.
And is there any interim order?
Lordship.
What is the interim order here?
Not to fill up the post of Lordship.
That is where in the second writ petition.
Second petition.
The first writ petition, there is no interim order.
Interim order is there. First petition also.
No, it says promotion will be subject to. outcome.
Subject of.
That is not interim order.
Subject of. After publication of the final gradation list, this order has been passed.
So now the promotion is to be given to the post of superintendent.
Divisional head assistant.
Divisional
Head assistant.
post is vacant.
Lordship.
Yes.
Lordship, affidavit in reply, we have annexed the recruitment process, how he has been appointed, Lordship. Recruitment process, how recruitment process has been done.
Affidavit and application file in which case?
Affidavit in reply has been filed in the Lordship 6236. We have called the Lordship the affidavit in reply. Page 129, Lordship. That has been received under the RT Act, Lordship. Where is it? Yeah. 3% has applied as per notice, and he is the only person eligible. Worksas employee has, Worksas 2 absent employee, 1 peon has applied. Out of this, he is the only person eligible in the recruitment process. Not recruitment process, as per notice.
No, I've not understood. What is this document? 129, what is this?
This is Lordship, the receive as per RTI information, Lordship. Before that, Lordship have to
What is your application?
RTI application.
What is the information you sought?
Information, sir, who have applied for the post of Worksas LDA then as per notice for applying to the post. How many persons have applied? Notice is at page 128. Notice has been issued specifically that we have already shown to your Honor Lordship on earlier occasion. That is the notice for recruitment process from Worksas employee, page 128.
So therefore, this is of 24/9 to 1993.
Lordship.
By this, a process was initiated for appointment of LDS.
This is not recruitment process. This is a notice for applying to the post of LDS then by executive engineer.
That's correct.
Yes.
This was made open to everyone who is eligible.
No, no.
Then,
This is only for Worksas employee.
so correct. So therefore, he did not become LDA because he was watcher employee. He became LDA because he participated in a process, submitted an application, and thereafter obtained the highest mark and got selected.
Lordship.
Then
But
what is the question of reverting him back?
no, no. Worksas employee, there is no quota in the recruitment process. There in the as per service rule, there is no quota reserved for LDS then.
This
Because
his
Assam
appointment
Minister-
was against a sanctioned vacant post.
No, originally not sanctioned vacant post.
Why?
He was
How do you
temporarily
say-
appointed to a post,
Then his regularization shows
regularized subsequently.
that's right. It is against a sanctioned vacant post. It
Ultimately,
is not an ex-cadet post.
that was ultimately a sanctioned vacant post.
Correct. So your argument is that the watchers khalasis were regularized against ex-cadet post.
Ex-cadre post.
But that is not the case in this case.
Originally, he was ex-cadre post. He was recruited to the LDS, then ex-cadre post. They are Worksas employees and ex-cadre post. It's personal post. Worksas employee is not a post created by the department.
Correct.
He was temporarily appointed as a Worksas employee. Here after notice has been issued, the eligible Worksas employee for post of LDS. 3 persons has applied. Out of him, he was one of the candidates. And he is the only eligible person. He has been appointed.
Correct. So what is
That's-
wrong with it?
That is the Lordship view.
You are saying once you are in watchers, that's the end of the road.
No,
It
no.
cannot be anything
No, no.
else.
My submission will be Lordship. The as per service rule, recruitment to the post of LDS then has been provided Assam District Establishment Ministerial Service Rule. There is no provision for quota for Worksas employee to the cadre of LDS. then. Recruitment process should be advertised or open to all by direct recruitment, not from Worksas employee. That provision has not been followed by the authority. Only Worksas employee has been asked to apply for the post of LDS. then. Within the division. That cannot be Lordship. We have appointed, we have been selected, appointed as per recruitment process, open advertisement. Everyone can apply. It has been issued violating the Article 14 and 16 of the Constitution of India. Recruitment process is illegal. Whole recruitment process is illegal against the norms and rules. When entry in the service is illegal.
All right, anything else?
So my submission will be Lordship. The Supreme Court has categorically stated, I have placed through judgment Lordship in this particular case. When a person has been appointed, devoted to the rules, recruitment rules, he cannot claim seniority and other things. It is for the authority, whether he will be reverted back or other things. I'm not against them. Because he has worked so many times, I'm not claiming that he should be reverted back or other things. But he cannot claim seniority over a regularly selected as per recruitment person, recruitment process he has been appointed. So he cannot overtake us. Supreme Court has categorically stated. I'll give the copy of the judgment, Lordship.
Which judgment? Rafiquddin? You're relying on which decision?
2014-13 SEC 232, State of Assam versus Chandrasekhar Pathak, where Supreme Court has categorically stated that absence of any advertisement and selection process, the appointment respondent is not protected and could not validly stand. So he cannot, when his initial footing is wrong, he cannot
overtake a person who has been regularly selected, regularly appointed to the cadre. Because my cause of action arose when the government has taken an action that all the casual employees or access employees who has been brought to the regular cadre by any process, contrary to the service rule, they should be reverted back. Other person in the works as employee has been reverted back, but he was left.
So in essence, what you are saying is, if you agree that if the court finds that his initial recruitment in the post of LDA was not dehorsed the rules, or for any reason it cannot be reopened today, then you don't have a case. That you agree.
I agree to that. Only, Lordship, I have not challenged. My prayer is that he should be reverted back to the works as employees or other thing that is for the authority to decide. But I am a regular candidate.
That's right. Followed. You want seniority. Whether
Senior.
he goes, he stays, you are not bothered.
I'm not bothered.
That's simple.
I'm not bothered.
That's the case.
Lordship.
So we'll ask them to justify how this recruitment is.
I'll
If
give
it
a
is in
copy.
accordance with rule, we'll dismiss the writ petitions.
Lordship.
That's all. And the seniority, I think Rafiquddin's case
Lordship.
is there. You got the judgment.
Lordship, Rafiquddin is referred in this particular case.
Yes. His initial recruitment has to be in accordance with the rules. It has to be valid.
Valid.
It should not be illegal. It will be illegal if the recruitment is not against regularization, is not against a
As per
sanctioned
rule.
post,
As per rule.
and it was not advertised. Because there are two things, illegal and irregular.
Irregular.
Illegal will be if there is no sanctioned post.
No, illegal is when recruitment possesses no advertisement to the open public, and it was limited to a some person without having the recruitment rule do not provide any
No, but
reservation.
this is the exercise of 1993.
93.
Yes.
The Supreme
So
Court has
judgments which are prior to 93 will only be applicable here.
Lordship, Supreme Court has categorically stated when we have discovered that his initial appointment is irregular and illegal, he cannot stand over me, Lordship. We can challenge Athens case. I place the judgment.
Who will argue first from the respondent? Anything else?
So one thing is left out. You're right, Lordship kindly peruse the notice by way of which the respondent number 5 has been recruited. That your Lordship will find in my affidavit in reply. If your Lordship go through it, then application from the willing work charge essay tracer khalasi. That means they are the only persons who can apply for the said post. Now, if your Lordship come to page 129, I have categorically put a question by way of an RTI that who were the persons who applied for the post, whether they were eligible or not. They were not eligible, Lordship. That your Lordship will find page 129, serial number 9. Vikas Chandra Das, he applied, he was a casual employee. He was not even eligible for applying to the post. Then serial number 12, Safiquddin Sheikh, he was a peon. He was not eligible. The entire recruitment process was designed in a manner to accommodate this person, respondent number 5, in that particular post, where it's strange to find that a copy of this notice has been personally served to him. That your Lordship will find at page 128 in the notice. Page 128, copy to Sukhendu Narayan Dhar, he is the respondent number 5. That means the entire mechanism has been designed in a manner where it was a pre-planned manner to accommodate this person, where persons who were not even eligible for applying, they applied.
Who did it? You have to, if this is an allegation of malafide.
Malafide, Lordship.
Then you have to make the person a party. Against whom are you alleging malafide?
Against this, we are challenging the selection process.
That's right. So you are saying somebody has designed the whole thing to accommodate the respondent.
Lordship.
Who is that person?
But prima facie, we are showing this honorable court. Lordship will kindly see. This Vikas Chandra Das, he was a peon. How can a person apply for a peon, holding the post of a peon, can apply in a recruitment process where he doesn't have the eligibility criteria, Lordship? That is our case, Lordship. We have challenged the entire selection process.
Every case, every issue has to be seen in the facts and circumstances.
Lordship.
Your arguments appear to be a little half-baked. You are not interested in anything else, Mr. Nayan.
Lordship.
Except for your client's seniority.
Lordship.
And we are not concerned about who is senior. We
Not
are
at all.
concerned about whether there is an infringement of
Lordship.
right. So we will look at it from the perspective of whether some illegality has happened here, which would have been challenged at the relevant point of time, but was not challenged. And therefore, what would be the consequence? We'll examine that.
I entered the department in the year 2011, Lordship.
Yes.
I was affected by the respondent number 5 by the promotion of respondent number 5 in the year 2007.
By the time you entered, he was already there. He was
Already there, but
regularized.
his initial appointment is illegal, Lordship. Prima facie, you are showing to this court, Lordship. This is illegal appointment, Lordship.
All right, let us see. What is this procedure by notice?
My lord,
Mr. Chakravarti, be brief and to the
absolutely.
point.
My
Don't
lord,
go here and there.
my lord,
Yes.
so my lord, may I draw your lordship's attention?
What is this
straight-
notice issued? What is the process followed?
My
Answer
lord,
that.
my learned friend has referred to that notice.
Hmm.
I find there is one discrepancy in typing a
Acha,
particular
you take your
word.
seat. Let me ask Mr. Das
My-
first. What was the procedure followed while recruiting the respondent number 5?
Lordship. Lordship, for this, I have to place the records, Lordship.
Hmm.
Everything will be
Yes.
transparent, Lordship. So may I pray for some time for
Huh?
placing the records of this case, Lordship?
No, no, and I'll finish off these matters today, this way or that way. Enough time was given. Last date also we made it
Lordship,
clear.
Lordship, although we have informed the department.
No adjournment. We'll record that despite calling for the record, it was not produced. And we'll draw adverse.
As a last chance, Lordship.
After hearing this matter for 45 minutes, now you are saying.
No, that is why, Lordship, I have mentioned in
What
the
kind of
morning.
conduct
morning
is this, Mr. Das?
Lordship, I do understand, Lordship. I do apologize for the same, Lordship.
You think
that is
this
why-
court is sitting here for cracking jokes?
No, Lordship, that is why I have mentioned in the morning
40
time,
minutes we heard this matter.
Lordship,
Now you are
Lordship,
saying you want time for.
Lordship. That
This
why-
is the only issue here. What else is there? These matters should be decided in 15 minutes.
Lordship.
If his recruitment is not illegal, then everything falls flat. If it is illegal, then only we'll see what is the prejudice and whether he could have challenged this at this point of time.
Lordship.
These are the 2 points here. We address the court on that. We'll deliver the judgment today itself.
Lordship.
Yes.
Then sometime may kindly be granted to me, Lordship, so that I can.
At 2, call
Lordship,
for the
Lordship,
record.
Lordship.
Get the records at 2 p.m.
Not possible.
No,
Lordship.
why not
It-
possible?
It will be coming from Silsar, Lordship. At least a week, Lordship.
This is pathetic. to say
On
that.
Monday, Lordship.
It raises a question on the bona fide of the department.
Lordship.
Who is the officer here? Tell him to be personally present with the
No,
record.
Lordship, it is a mistake on my part, Lordship. I do apologize for the same, Lordship.
What is your stand?
My lord, to be very concise.
You know how much of inconvenience it causes to the judge. We have taken a note of everything,
Lordship.
and then we have to redo the whole exercise.
No, Lordship.
There will be a cost of 50,000. I'll grant you time.
Lordship.
Somebody
At
has
two,
to
Lordship.
pay the
At
price.
2, Lordship.
No, was there not an at 2? Yeah, you get your record at 2.
Lordship, at 2. Then I will.
Alright. Then we'll take up the matter at 2.
Lordship,
When the record is called for, it must come to the court.
Lordship, that,
If it doesn't come, then we know how to get it.
Lordship, that is why I have mentioned in the morning time only. My learned friend and objected to the same, Lordship. In the morning time only, I have
But this
mentioned.
matter was fixed last week only.
Lordship, Lordship.
Was it not made clear that
I-
it will be taken up today?
I do understand.
Then why the record was not there?
I do understand, Lordship.
Seems court orders are not being
No.
taken seriously by
No.
anyone.
No, Lordship, we have taken it seriously, Lordship.
Coming across these instances,
Lordship.
Mr. Das, this is not
He was not
taken.
here on the last occasion.
Lordship,
Something will
I
not
was
be
not
taken
there,
so
Lordship,
lightly.
and moreover, I have mentioned in the morning time only, Lordship, my friend had objected,
No, question is not mentioning. Question is why the record is not here. We
Lordship,
called for the record.
Lordship,
Why is it not here? Silchar is not overseas.
Lordship, I do understand, Lordship,
Silchar is not overseas.
Lordship.
You get the record at 2. Or else we'll direct personal appearance of the chief engineer on the ground that he is not responding to the court's order. Even if you don't get the record, tell him to come to the court
Lordship,
at 2. If you don't have the record, you ask your chief engineer to come here. He has to answer these questions. Yes, next matter.
Yes, your Lordship. My lord, by an advertisement at page annexure 1, my lord, the post of process server and peons were advertised. Total 11 numbers of vote at page 12. Five numbers of post of process server and 6 numbers of posts of peons. Then, my lord, at page 14, annexure 2, a select list was published, in which at item number 1, process server, the petition number 1's name is there. And item number 8, name of petition number 2 for the post of peon.
What is your case, Mr.?
My lord, thereafter another select list was,
No, what is your case?
my case, we got selected as per the published list, but we were not appointed. Another list is there showing the name of, dropping our name. Other names are there, only our names were dropped.
Where is the select list where your names are there?
So at page 14, my lord,
Page 14.
yes, annexure 2, item 1 and item 8. Alimuddin Loskar and Firujuddin Borbe.
How many posts were there?
11 numbers of posts were advertised. The next list was prepared with the names of 9 persons. Annexure 3 at page 15, my lord.
Hmm.
Here our names were
Dropped.
dropped. Curiously enough, both these orders are with same memo number under signature of same IAS officer, deputy commissioner, with the signature also of his office assistant. Under same date, on same date, same signatures. So there must be, one of the list must be fake, my lord.
Hmm. So how are we supposed to decide?
That's why I prayed, my lord, in my additional affidavit, the whole matter may be remitted to the chief secretary to the government of Assam. A senior IAS officer has done this, my lord. We have also produced original copy of the our select list, along with that additional
Where is the original copy? Let us see.
additional affidavit.
Here, Mr. Chutia, what is this?
Yes, we have filed affidavit. It is false, my lord. This select list annexed by the petitioner is made in his own factory, not from the government, my lord. Lordship, kindly see our my lord, affidavit.
If that is so, that should be.
Yes, yes,
prosecuted, my
lord.
You lodge FIR then. You lodge FIR.
Kindly
Yes, yes.
see our
I
affidavit.
agree to that. I agree to that. Your lordship may compare the full list, same signatures of same office assistant, original list I have submitted.
Signature is different.
Even
And why
if-
did you not lodge an FIR if
Yes.
this is forged?
No, my lord, we don't know, my lord. He annexed this select list. It is not select list, my lord.
Mr. Chutia, if you are saying that somebody has taken out a
Yes,
false
yes.
select list, the government will not take
They
action.
should actually, they could have filed an FIR, my lord.
Why they have? not
Definitely,
done?
my lord. No, anyhow, my lord, matter is pending. They have filed an affidavit. Lordship, go through the affidavit. Lordship, kindly see the affidavit filed by the respondent to Deputy Commissioner.
Hmm.
Rajiv Roy. Lordship, kindly see. Paragraph 4, with regards to disposition, best to the Deputy Commissioner Highland issued an advertisement dated 4/1/2014, inviting application for 5th vacant post of PS and 6 post of including 2 post of peon for reserve compensation appointment. Paragraph 5, Lordship, kindly see. Statement made in paragraph 3 to read petition, it begs to state that deny the correctness of the same and further begs to state that no select list containing 11 numbers of candidates with the name of the petitioner as per annexure 2 of the read petition was prepared and published on 26/12/2014. The Deputy Commissioner highlighted the prepared a select list dated 26/12/14 for filling up the aforesaid categories of posts containing 5 candidates for post of PS and 4 candidates for the post of peon. And it was hanged in the notice board of Deputy Commissioner Hailakandi. In the said select list, neither the name of the petitioner nor the name of the petitioner number 2 were there in the serial number 1 and 8. The select list annexed with the petition annex 2 seems to be not genuine. It is also stated that picture number 1 and 2 participated in the selection process. They could not selected in order made. They got only 17 and 11 marks. Lordship, kindly see our annexer. Select list, original select list. Page 8. This is a select list signed by all the members of the committee.
You're referring to which affidavit?
Our affidavit, my lord.
Affidavit by respondent number?
2. I see Rajiv Roy.
There is one affidavit by respondent number 2, Jyotirmor Doimari.
Jyotima Dubai also is also sub-divisional officer, my lord. Same contention, my lord. Lordship,
There
kindly
is
see.
no affidavit by Rajiv Roy. Please take it up.
If I have all the signature of an IAS officer, and that is, IAS officer is still working.
Mr.
Okay.
Whatever else it is, no mandamus can be issued in favor of your client. You can understand that.
Yes, my lord.
Because
That's
these are
why,
dispute, which is genuine, which is not, we don't know.
that's why my prayer is to send it to chief secretary for an inquiry, my lord, only. Because such a senior IAS officer has put 2 signatures in 2 different papers.
An FIR be registered.
Yes, that's how I will come, my lord.
Rajiv Roy.
Where is it?
Yes, ma'am.
Mr. Chutia, please find out what is to be done. We'll come back in 5 minutes.
Yes.
You ask your.
My lord, as per my lord, affidavit, my lord, that is select list is not, my lord, genuine.
That's all right, but you know that there are false select lists. You are keeping quiet on the matter.
That is, my lord, they have filed an affidavit, they are waiting for the, my lord, I think, my lord, verdict of-
What do you want to do? If leave is granted, what do you want to do? Tell us.
No, man.
5 minutes, we'll come back. Today I'll finish off this matter.
Yes, yes, ma'am.
What is the leave you want?
So I have received a record also, original record.
Yes,
Affidavit is there, my lord. Rajiv Roy. Number 2. Paragraph 5 we have stated here, my lord.
so what is to be done here?
No, my lord, there is no merit at all, my lord. We have, I have got the, my lord, original record, my lordship can go through it, my lord. Selection, selected candidate. How they have got it, marks.
So what has happened? The selected candidate is already appointed.
Already appointed, my lord. 2014 select list, my lord.
There is no interim order in this case.
No interim order.
Lodge affairs
Yes, yes.
and case will be registered. That's
Yes.
all.
And also the matter may be inquired by chief secretary
No,
because
no, Chief Secretary.
he is also a senior IAS officer, the other person. Obviously,
Nothing. You lodge, this is a criminal case.
Yes.
You lodge an FIR and then
yes,
take down, take down. Heard Mr. NH Majar Bhaiya Learned Counsel appearing for the writ petitioners. Also heard Mr. T.C. Chutia Learned Additional Senior Government Advocate Assam appearing for the respondents. First up, the facts of the case, in a nutshell, are that on 04/01/2014, the Deputy Commissioner of Hailakandi, that is the respondent number 2, he had invited applications for filling up 5 vacant posts of what is this? PS means
PSP, my lord, statistical.
process server. Process server.
Process server.
process server, and 6 posts of peon.
Peon. Out of 6, 2 posts reserved for compulsory
Full
appointment.
stop. Out of the 6 posts of peon, 2 were reserved for
Compulsory appointment.
being filled up by way of compassionate appointment. Full stop. The petitioner herein claimed to have participated in the aforesaid recruitment process. According to the petitioners, a select list was published on 26/12/2014, containing the name of 11 selected candidates. Full stop. In the said select list, the name of the petitioners appeared in serial number 1 and 8 respectively. Full stop. Notwithstanding the same, no order of appointment were issued in their favor. On the contrary, another select list dated 26/12/2014 was published, which contained the name of 9 selected candidates, but the petitioner's name did not feature therein. Full stop. Contending that the respondents have changed the select list only to favor persons of their choice. The instant writ petition has been filed. Full stop. Next. By filing an affidavit, the respondent number 2 has categorically stated that the select list dated 26/12/2014 containing the name of 11 candidates is not genuine in as much as no such select list was published by the authorities. Full stop. Rather, the departmental authorities have authenticated the select list dated 26/12/2014 containing the name of 9 selected candidates, which did not include the names of the 2 petitioners. Full stop. Mr. Chutia, learned additional senior government, has also argued that the select list containing the name of 9 candidates, including the petitioners, is a forged one and was never published by the competent authority. Full stop. If that be so, it is apparent that there is a serious disputed question of fact as regards which of the 2 select lists are valid, which cannot be decided in a writ petition. Full stop. Moreover, if it is really the case that a forged select list shown to have been published by the respondent number 2 is available in the records of this case, the matter calls for further investigation under the provisions of the CRPC. Full stop. However, since no FIR has been lodged by either side, the machinery under the CRPC apparently was not activated in this case. Full stop. As such, by granting liberty to the parties to take appropriate legal recourse in the matter as may be permitted in the facts and circumstances of the case, this writ petition stands closed.
Item 6.
May please, your lordship. Lordship, I am appearing in item number 6 for the petitioner, lordship. So actually our file has been misplaced, lordship. So I pray only 2 days time, lordship, to locate the file, lordship.
You want it after 2 days,
Yes, lordship.
but before 20 days, we don't have time. What to do?
Okay, then after 20 days, lordship.
Yes, ma'am.
All right. Ms. B. Devi, like counsel appearing for the writ petitioner in item 6 submits that the records have been misplaced in her office and therefore admission hearing of this matter be postponed by 2 weeks. Mr. S.K. Medhi, learned CGC, is present and does not have any objection if the prayer is allowed. Also heard Mr. J. Patwari, learned counsel for the writ petitioner in item 5, who, although has expressed urgency in the matter, does not oppose the prayer for posting these matters again after 2 weeks. Registry to take note of this order and list the matters accordingly. All right.
Please, lordship, though I am not named in this petition, lordship, I am appearing on behalf of Mr. P. Botwell, lordship. Also, this matter pertains to the appointment of Gambura, lordship, and the advertisement was published violating the norms of executive instruction, lordship, where the preference will be given to the family of the Gambura. That clause has not been incorporated, lordship,
Clause has not been incorporated where?
in the advertisement, lordship. That
What is
is,
Where is the advertisement?
Lordship, page number 40.
This is an advertisement of 2019.
Yes, Lordship.
So what has happened? The selection is,
Thereafter, Lordship, the petitioner submitted the representation, Lordship, and the authority verbally assured the petitioner that they will issue a corrigendum incorporating this clause, Lordship. But in the meantime, Lordship, the interview was called for, and accordingly, Lordship, the petitioner also appeared, Lordship, and that time also petitioner give the reminder to the authority, Lordship. But the authority, Lordship, on 16/9/19, Lordship, appointed the respondent number 7 as the Gaura, Lordship.
appointment already made.
Yes, Lord, that has been stay, Lordship. That is stay, Lordship.
That is stayed.
Lordship.
Appointment order has been stayed.
Yes, the status quo was
So
there.
now you want that the advertisement should be changed, the whole thing should be done again. Then your client should be selected and set aside the appointment to respond number 7. Is that what you want? But that cannot be done. That cannot be done merely because the clause in the advertisement which you wanted is not there.
But it is, Lordship.
Clock cannot be set back. Come next time when the advertisement is issued. We'll ask them to consider this aspect. Where is your representation?
Representation, Lordship. Page 43.
Page 40.
43, Lordship.
You are for whom?
And for the private respondent number 7, my lord,
There is a stay order.
there is a status stay.
All right. Heard Miss
M. Nirvala,
M.
Lordship.
Nerulan and a counsel appearing for the writ petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the respondent numbers 1 to 7. Mr. P.D. Nayal and a counsel is present on behalf of respondent number 7. And who is for 8? None has appeared for respondent number 8. Full stop.
I is disposed of, Lordship.
Who is the respondent number 8? Who is he?
Appointed in different.
Obesh Talgo. He has been appointed as a Gambura of different village. He is
Different.
alleging for a different village. I am selected for a different village. The same recruitment process.
Okay, you are also challenging. You are
No,
also
no,
fight.
no, I have been already appointed. I have filed a petition.
Okay, Mr. S.K. Goswami and counsel is present on behalf of the respondent number 8. Full stop. In this writ petition, a challenge has been made to the selection and appoint of respondent number 7 as the Gaubura of, in respect of Bagmara. Gaubura of Bagmara, is it?
This petitioner is concerned for Mahina, Lordship.
Mohina Gau.
Gaubura of Mahina Gau, Mahina Gau, in the district of Nalbari, Assam. Full stop. The case of the petitioner in a nutshell, is that on one 8/2019, the Deputy Commissioner of Nalbari, that is the respondent number 4, had issued an advertisement notice inviting applications for
2 villages.
filling up the posts of Gauburas in Mahina Gau as well as Bagmara Gau in the district of Nalbari. Full stop. The advertisement notice did not, however, contain any clause which seeks to give preference to the family members of ex-Gauburas. Full stop. Aggrieved thereby, the writ petitioner had submitted a representation dated 10/8/2019 before the respondent number 4 with a prayer to include such a preferential clause in the advertisement notice dated 1/8/2019. However, no action was taken on the aforesaid representation of the petitioner. First up, the petitioner had participated in the selection process, but did not get selected. First up, eventually, the respondent number 7 was selected for Mahina Gaon, whereas the respondent number 8 was selected for appointment as Gaubura in the Bagmara village. First up. Since the petitioner has not challenged the selection and appointment of respondent number 8, they said respondent number 8, his court would refrain from dealing with the said aspect of the matter. First up, the only challenge in this writ petition is to the selection and appointment of the Gaubura of Mahina Gaon. That is the selection and appointment of respondent number 7. First up, what is to be noted here in that the selection process has already been concluded and the petitioner has also participated in the said selection process, but has emerged as unsuccessful candidate. First up, there is no other ground urged by the petitioner to interfere with the selection and appointment of the respondent number 7. First of all, under the circumstances, there is no justifiable ground for this court to entertain the writ petition or to interfere with the selection and appointment of the respondent number 7 on the case projected in the writ petition. First of all, this writ petition is therefore held to be devoid of any merit and is accordingly closed. Interim order passed earlier stands vacated. Notwithstanding the order passed in this case, it will be open for the respondent authorities to consider as to whether a clause giving preferential treatment to the family members of ex Gaubura should be incorporated in the advertisement notice for appointment of Gauburas in future. Full stop. Writ petition stands disposed of accordingly.
This petitioner is working as worker employees since 1984. And in the year, my lord, 2005, my lord, they have regularized the service of 567 similarly situated persons, debarring the petitioner. And subsequently.
Debarring the petition.
Yeah, not debarring, my lord, excluding the petition. And subsequently, they have filed an affidavit in the, my lord, this code, saying that, my lord, 2005, my lord, his post was, he was regularized, but it was cancelled by the finance department. There is no reason for it. And your lordship will kindly see that page 19. Work charge Khalasi, and page 25, your lordship may kindly see. And he is not getting salary for last 20 months. And
minimum pay scale to buy, sir. Lordship, may I submit, lordship? Lordship, in this case, last date, your lordship directed me to file my affidavit, lordship. My affidavit has already been sent for vetting, lordship. So I'm filing it very soon, lordship. Lordship will take up this matter after 2 weeks, lordship. His regularization was cancelled primarily because of the reason that all the persons regularized were appointed prior to 1993. But in his case, lordship, he was regularized inadvertently, lordship, and his appointment was only in the year 1999, lordship.
no, 1984, my lord. I have
1999.
enclosed it, my lord.
That was the reason
Mr.
for.
Das, the affidavit will be necessary to decide this
They
case.
should file it, my lord. I filed this case long time back, 22, and they are
Alright,
not
alright.
getting salaries also.
I understand. We'll give you a firm date, 31st of May. 31st May. Heard Mr. B.D. Das, Managing Senior Counsel appearing to the writ petitioner. Also heard Mr. P. Nayak, Leonard.
I'm for
Standing
finance,
Counsel.
lord. Finance.
Finance Department has would submit that affidavit on behalf of the department is ready and has been sent for waiting. First up, assuring this court that the affidavit will be brought on record on or before 26th of May. 26th of May. File it by 26th of May,
Lordship, lordship.
2023 by serving advance copy upon the petitioner's counsel, Mr. Nayak prays for posting this matter again on 31st of May 2023. Prayer allowed. It is however, made clear that since the petitioner is going without salary.
No,
since-
he is getting the current salary.
20 months salary is pending, madam. Let them take it.
Since, it is however made clear that since the petitioner has not been paid salary for 20 months, there is urgency in the matter, and therefore no prayer for adjournment on the ground of filing of affidavit by the department will be entertained on the next day.
They will come for admission.
This case again on 31/5/2023 for admission.
Salary part.
In this matter, government was directed to produce the records.
Lordship, I received the records, Lordship.
What is the review petition?
Lordship, review petition is that, Lordship, we have challenged the appointment of the private respondent who already earlier filed a writ petition before this court, and we are not party, and the writ petitioner is not a party in that writ petition, Lordship. That is annexure.
You have received the records.
Lordship.
You will take up the matter.
Lordship. But at the same time, Lordship, after perusal of the records, Lordship, some point is missing here in this record. So the issue is that, Lordship, the Anganwadi center, if before creating an Anganwadi center, Lordship, one survey was made, Lordship, and a survey of the household, total household of within that Anganwadi center area, Lordship. It is called Anganwadi center area, Lordship. And issue of the petitioner is that the petitioner is not belongs to that area, Lordship, and the respondent is belongs to that area, and therefore the respondent was selected, Lordship. But the list of the survey report is not appeared in the record, Lordship. Therefore, if I may be allowed to produce the survey report, Lordship.
Heard Ms. Archavi, counsel for the petitioner, also heard Mr. J.K. Goswami, learned additional senior government advocate Assam, who submits that although he has received the records, yet the survey report is not readily available. Considering the fact that the survey report is the document which will throw light on the real controversy in this writ petition. In this proceeding, Mr. Goswami seeks 10 days time to produce the same. Let these matters be listed again after 2 weeks. The survey report shall be made available on the next date.
Any date, Lordship?
2 weeks.
Obliged.
There's a interest component that has been admitted by us, my lord. AG has been, office of the AG has been moved, my lord, to release that amount.
Well, show me something. Heard Mr. J. Kalita, learned counsel for the petitioner, also heard Mr. D. Gogoi, learned counsel appearing for the respondent, who submits that the interest component as claimed by the petitioner is admitted by the department, and accordingly, the office of the principal accountant general bracket ANE, Assam has been moved for release of the amount. Move for release of the amount. In support of his above argument, Mr. Gogoi has produced a copy of the office order dated 4/1/2023. I have perused the same.
A copy may be provided to me, Lordship. And Lordship may take up the matter after 2 weeks or 3 weeks, Lordship.
On the request of Mr. Gogoi, this matter stands adjourned for 4 weeks.
Yes.
So as to enable him to obtain updated instruction. Meanwhile, a copy of the communication dated 4/1/2023 be furnished to Mr. Kalita.
Obliged.
Item 10.
May please your lordship. I would request some time to file my affidavit, my lord.
In this case, I have some objections, my lord. Because they have given time 6 months back to file on this. They have not filed a single affidavit.
My
What
lord,
is the, my lord, this is a compulsory, this is a compulsory appointment case, my lord. They want to compare that we are not eligible because our financial category is much more than what they have, what we want to say that, I want to say that. There are other, there are 15 candidates they have selected, but not considering my case. But we are, but there are some vacant, there are more than vacant posts that is necessary for the post they are applying, my lord. The post they have applied, I think, I think for the vacant post is 40 or 900, and 5% is just for that compulsory appointment scheme. So, my lord, the 5%, it comes to around 45. They have selected only 15. So what I want to say is that there are vacant posts, still they have not considered my case. That is how in this connection, they want to submit an affidavit, but still 6 months have passed, they have not filed a single affidavit. All right, heard Mr. S. Mitchell, or counsel for the petitioner. The petitioners are before this court. The petitioner is before this court aggrieved by non-consideration of his case for appointment on compassionate ground due to want of vacancies. Mr. Mitra submits that although there are sufficient vacancies available in the department, the prayer of the petitioner was arbitrarily rejected. Mr. S.P. Sharma, learned counsel appearing for the APDCL, prays for 2 weeks further time to file affidavit. Having regard to the nature of controversy, this court is of the opinion that one more opportunity should be given to the respondents to file affidavit. Registry to therefore list this matter for admission after 3 weeks as fixed item. The departmental authorities are granted 2 weeks time to file affidavit. Failing which this matter will be taken up for disposal on the basis of materials already available on. After 3 weeks counted from today, you will know the 3 weeks. Fixed item myself. Yes.
May it please your lordships. Not in this writ petition. We are
What is
assailing,
this? Looks like some big matter.
not very big.
You dragged Mr. Kohli from Delhi to go.
Yeah, yeah.
Something big must be.
This is lordship that one of the APSC related matters. And this would, I don't know how far my
No, I don't
senior,
think long, it's a very short.
but I'm certain that I will be taking a little time.
Yeah.
Deeply obliged.
What had happened, my lord? We are assailing an order of discharge. Now, before that, my lord, there are certain factual aspects which needs to be highlighted.
Where
my
is the order, Mr. Chaudhary?
Yes, it's at page number 121, my lord. The governor of Assam in exercise of powers interiorly under Rule 21 of the Assam Agricultural Service Rule 1980 is pleased to discharge Mr. Sri Mrigan Haloi, Agriculture Development Officer, so and so. I was a provisioner from service of the state government with immediate effect. So this is the order.
So discharge of probationer.
Provision. Now, what had happened, my lord? There was an FIR lodged at page 69. Now, my lord will kindly note the date. It is 17/8/2017. And I was appointed sometimes in 2015 as a provisioner. Humble submission is that I was a candidate for the post of Agriculture Development Officer.
Skip that. Skip that. Yes. Yes,
Yes. I have passed the exam, written examination, which was held in the year 2014. I have appeared for Viva Voce, which was held in the year 2015. Unfortunately, I did not clear the examination because of bribe of rupees 15 lakhs was demanded from me by the then chairman, Rakesh Kumar Paul, and his agent, Musharraf Hussain. According to me, both of them conspired to took rupees 15 lakhs from some other candidates and selected him in place of me. On the other hand, I gave an advance of rupees 50,000 to him at so and so. Likewise, Assam Public Service Commission took money from many other candidates and provided them job. And by knowing this, I too gave money. Moreover, I was a reserved category candidate. Resultantly, in view of my suspicion, I applied for the relevant documents in respect of the Viva Voce under Right to Information Act. Under this reserved category, it has come to view that another 5 candidates, namely Mrigan Haller, that is the petitioner, bearing a roll number so and so scored 78 marks in the Viva Voce, and in the other Right to Information, it has come to my view that same candidate in the same Viva Voce scored 80 marks, meaning thereby different information was provided. Therefore, regarding this matter, I lodged this complaint and it is prayed before good self to investigate, etc. etc. Well, the fact of the matter is, the gentleman, he waited for more than 18 months, then lodged this FIR. Now, my lord, the person to this FIR, my lord, the petitioner was arrested. Then, my lord, he was enlarged on bail by an order dated 26/7/2019. In the meantime, my lord, at page 83, the petitioner was placed under suspension. Page 83.
yes.
Whereas Sri Mrigan Halloy, Agriculture Development Officer, was arrested by the Additional Superintendent of Police Headquarters in connection with Bhangaghar PS case number so and so, in connection with so and so so and so. The Governor of Assam, in exercise of power conferred under Sub-Rule 2 of Rule 6 of the Assam Services Discipline Appeal Rule, is pleased to order that Mrigan Halloy, Agriculture Development Officer, is deemed to have been placed under suspension with effect from the date of his arrest, that is 9/5/2019, until further orders. So, my lord, it is a case of a deemed suspension under Sub-Rule 2 of Rule 16. Then, my lord, because the suspension of the petitioner was not reviewed in terms of the judgment in my lord Ajay Chaudhary, we preferred a writ petition. That is WPC 8229 of 2019, whereby judgment dated 28/11/19, my lord, the suspension order was, my lord, interfered with, which your lordship will find at page 85 it starts, and the operative portion is at page 89. Page 89, 16, 17, 18. Accordingly, the impugned suspension order of the petitioner and the consequential notification as well as so and so, all issued by the Secretary to the Government of Assam in the Agriculture Department, being not sustainable in law, are hereby set aside and quashed. Accordingly, the respondents in the Agriculture Department of the state shall reinstate the petitioner as Agriculture Development Officer or any other equivalent post under the Government of Assam in the Agriculture Department for which it is up to the respondents' Agriculture Department to decide regarding posting of the petitioner on his reinstatement. Now, para 18 is very important, my lord. However, it is made clear that respondent department may initiate disciplinary proceeding against the petitioner in accordance with law and to complete the same at an early date, with further observation that petitioner shall participate in the same towards its early completion. So, my lord, the suspension order was interfered with, and all the consequential orders were also interfered with, and the petitioner was directed to be reinstated in service. However, liberty was given to the department to proceed departmentally and to conclude the disciplinary proceeding expeditiously. Well, against the judgment, a writ appeal was preferred by the state. Amongst others, my lord, one of the ground was that benefit of Ajay Chaudhary cannot be given to a deemed suspension. In case of a suspension under Rule 6(1), that benefit would be available. But in
That
case
is,
of
that
a
is
deemed
decided in Recruitment's case. I think.
prior to that, correct.
Prior to that.
Anyway, my lord, the writ appeal was dismissed filed by the state. That your lordships will get at page 91. I'm not troubling your lordships. Lordship may kindly take note, and operative portions are at page 104, 5 and 6. Now, after that, my lord, they issued a show cause notice that your lordships will get at 107. That you are hereby required to show cause under Rule 9 of the Assam Services Discipline Appeal Rule. Read with Article 311 of the Constitution, why any of the penalties prescribed in Rule 7 of the rule should not be inflicted upon you on the basis of the following charges framed on the statement of allegations attached herein. That while you working as AOD so-and-so, arrested by Additional Superintendent of Police Morigaon in connection with Bhangar PS case number so-and-so for offences under so-and-so, based on the FIR lodged by Vedanta Vikas Das, Sonitpur in connection with APSC cash job scam on so-and-so and remained in police custody beyond 48 hours. So-and-so, you are therefore charged with gross negligence, etc., etc., etc. Then, my lord, I was asked to submit written statement of defense. Then, my lord, we also submitted our reply to the show cause notice that your lordships will get it 111. Now, my lord, without taking the disciplinary proceeding to its logical end, midway, my lord, they invoked power under Rule 21 of the service rule and discharged me from my service.
You are in probation at that time.
Probation. This is the facts.
No, but can it not be done?
Yes, it can be done,
Probation, it can be done.
provided it is not founded. If the allegation, if it is not founded on allegations, yes. But if it is not found, if it is founded on allegations, then no. Yes. And my lord, even the disciplinary proceeding can also be aborted in the midway.
Which is the Dipta Prakash Banerjee, is it?
No.
Which is then
Yes, Dipti Prakash Banerjee, then Radhesham Gupta.
Radhesham Gupta.
It all started with Purushottam Lal Dhingra, Samsher Singh, and all these line of cases. Now, my lord, our simple case is, admittedly, because, my lord, kindly see, first there is an arrest, an FIR. My lord, what is the allegation? That RTI information revealed that 78 was given in interview component and another information says it is 80. But we checked up, my lord. My selection was based on 78 mark, not on 80. Be that as it may. My lord, I'm not troubling our lordship with the merits. Now the question is, I'm assailing the decision-making process. Now I'll satisfy your lordships why the
So
court.
according to you, they were obliged to hold an inquiry and then.
Yes,
find the guilty.
because they have taken note of some misconduct on my part. That means when I entered service, I adopted some wrong means. That is the reason. So that means that is a misconduct. That is an action which is not in conformity with the law. Therefore, you have taken note of some allegation against me. It is.
But what is this? Let us just cut this for a moment into a little shorter scheme. Motive and foundation.
Yes.
Is that, now, there is no stigma attached to the order.
No, again, my lord, merely because my lord, the order is innocuous, necessarily it will not lead to the conclusion it is not stigmatic. It all depends upon the facts of the case. My lord, I think one or two case law will cleanse the issue.
Yes.
Now, my lord, the lordship knows in that APS and ACS, there is a judgment by a single judge of this honorable court. That judgment, my lord, in my humble submission, is a judgment rendered on the facts of that case. There in this affidavit, the state pleaded that based on the allegations in the police case, we have taken action. Yet learned single judge did not interfere. And my lord, the learned single judge in one of the paragraph of the judgment, we refer to a judgment called State Bank of India versus Palak Modi. That was a case, my lord, regarding a recruitment of, my lord, some officers in the State Bank of India. There, my lord, on the ground that some unfair means were adopted while seeking recruitment. Therefore, those terminate discharge orders were issued, which Supreme Court interfered. Now, the learned single judge, while deciding the ACS and APS matter, has recorded in one of the paragraphs all the decisions which the petitioner side had, my lord, placed reliance upon are all judgment relating to cases where one has entered service. Thereafter, those observations were made. None of the judgments were pointed towards the fact that even if there is something wrong in the recruitment process, then this power can be invoked. Well, Lord, Palak Modi was the case which is that issue was answered. Now, the allegation against me is I adopted unfair means in getting employment. That is why, my lord, I was arrested. That is why, my lord, I was suspended. And my lord, in the disciplinary proceeding, the charges that my act is unbecoming because I was arrested in so and so case. So in any case, my lord, even if in the disciplinary proceeding, if I have been, my lord, found guilty also, then ultimately if I succeed in the criminal case, everything will, be squared up, my lord. The question is, here is a case which is based on some allegation. Once there are certain allegations against a provisioner, my lord, then whether Article 311 can be dispensed. That is the issue. Well, I'll just place few judgments. That is my argument, my lord.
There are allegations, but you have not been found guilty.
Yes, not found guilty. Not to speak of guilty, that inquiry has not yet been concluded. Now, first I'll place, my lord, Samsen Singh's case. Judgment kita diwane ki? 1974, 2 SCC 831. My lord will kindly come to para 62 at page 850. '62 paragraph at page 850.
Para 62.
62, my lord. Para 62 and 80. These are the two paragraphs I'll read.
Yes.
The position of a provisioner was considered by this court in Purushottam Lal Dhingra. Das CJ speaking for the court said, where a person is appointed to a permanent post in government service on provision, the termination of his service during or at the end of the period of provision will not ordinarily and by itself be punishment, because government servants who are appointed has no right to continue to hold such a post anymore than servant employed on provision by a private employer is entitled to do so. Such a termination does not operate as a forfeiture of any right of a servant to hold the post, for he has no such right. Obviously, such a termination cannot be dismissal, removal, or reduction in rank by your punishment. There are, however, two important observations of Das CJ in Dhingra. One is that if a right exists under the contract or service, rule to terminate the service, the motive operating on the might of the government is wholly irrelevant. The other is that if termination of service sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is a punishment and violates Article 311. The reasoning why motive is said to be relevant is that it inheres in the state of mind which is not discernible. On the other hand, if termination is founded on misconduct, it is objective and is manifest. No abstract proposition can be laid down where the service of a provisioner terminated without saying anything more in the order of termination, then that the services are terminated, it can never amount to a punishment in the facts and circumstance of the case. This is the line, my lord. If a provisioner is discharged on the ground of misconduct or inefficiency or for similar reason, without proper inquiry and without his getting a reasonable opportunity of showing cause against his discharge, it may in a given case amount to removal from service within the meaning of Article 311(2). But before a provisioner is confirmed, the authority concerned is under an obligation to consider whether work of the provisioner is satisfactory or whether it is suitable for the post. In the absence of any rule governing a provisioner in this respect, the authority may come to the conclusion that on account of inadequacy for the job or for any temperamental or other object not involving moral turpitude, the provisioner is unsuitable for the job and hence must be discharged. No punishment is involved in this case. The authority may in some cases be of the view that conduct of the provisioner may result in dismissal or removal on an inquiry. But in those cases, the authority may not hold an inquiry and may simply discharge the provisioner with a view to giving him a chance to make good in other walks of life without a stigma at the time of the termination of a provisioner. If, on the other hand, the provisioner is faced with an inquiry on the charge of misconduct or inefficiency or corruption, and if his services are terminated without following provisions of 311(2), he can claim protection. So this is the proposition, my lord. Then if your lordship will kindly come to paragraph 80 at page 855. Now, in the facts of this case, what was said? The order of termination of service of Ishwar San is clearly by a punishment in the facts and circumstances of the case. The High Court not only denied Ishwar San Agarwala the protection under 131, no, it should be 311, but also denied itself the dignified control over the subordinate judiciary. The form of the order is not decisive as to whether order is by way of punishment. Even an innocuously worded order terminating service may, in fact and circumstances of the case, establish that an inquiry into the allegation of serious and grave character of misconduct involving stigma has been made in infraction of the provisions of Article 311. In such a case, the simplicity of the form of the order will not give any sanctity. This is exactly what has happened in case of Ishwar San Agarwal. The order of termination is illegal and must be set aside. So, my lord, the form of the order is not very material. What is material is, my lord, under what circumstances the order has been passed. Then, my lord, the next case which I'll rely is 1985, 1 SCC 56. My lord will kindly come to paragraph 7 at page 60. It seems to us that the High Court has failed to consider the true content of the case set up by the appellant. The entire thrust of the appellant's case is that in terminating the appellant's service, the competent authority treated him unfairly and arbitrarily. It is well settled that in dealing with a government servant, the state must conform to the constitutional requirement of Article 14 and 16. An arbitrary exercise of power by the state violates those constitutional guarantees. For a fundamental implication in the guarantee of equality and of protection against discrimination is that fairness and just treatment will be accorded to all, whether individually or jointly or as a class. When a government servant satisfies the court prima facie that an order terminating his service violates Article 14 and 16, the competent authority must discharge the burden of showing that power to terminate the service was exercised honestly and in good faith on valid consideration and fairly when without discrimination. So this is what lordships will expect from the other side, when my learned friend, my lord, open up his case. My lord will kindly come to paragraph 10. Proceeding from there, we may advert to the further aspect of the case. It would seem that dominating factor which influenced the mind of the Deputy Inspector General was the allegation that appellant had married a second wife against the government servants' conduct rule. It is clear that a full-fledged inquiry was instituted into the matter. Evidence was recorded, but before any findings could be rendered, the inquiry was dropped for want of jurisdiction. No attempt was made thereafter to institute a proper inquiry by the appropriate party. In these circumstances, it was not open to the Superintendent of Police to mention in his report as a statement of fact that appellant had married a second time against government servants conduct rule. With the dropping of the inquiry, the allegation remained unverified. We may observe that where allegations of misconduct are leveled against a government servant, it is a case where provisions of Article 11(2) of the Constitution should be applied. It is not open to the competent authority to take the view that holding of inquiry contemplated by that clause would be a bother or a nuisance, and that therefore it is entitled to avoid the mandate of that provision and resort to a guise of an ex specie innocuous termination order. The court will view with great disfavor any attempt to circumvent any constitutional provision of Article 311(2) in a case where that provision comes into play. Now, para 12, the appeal is allowed and order dated of the Deputy Inspector General is quashed. My lord, I am a government servant. I have been appointed after a selection. There is some, my lord, an unsuccessful candidate, he lodges an FIR. Now, fully in the criminal case, nothing has happened till date, my lord. Now, the disciplinary proceeding.
What has happened to the selection of that particular batch?
Nothing has happened. Everybody is working.
Only one person.
Only I have been picked up.
Is that correct?
Lordship,
Just
on this direct, just on this question only. Lordship, they are all part of the same batch, and the law on this was that if you can identify the tainted, then you don't scrap the entire selection, which is the law laid down by the Supreme Court. However, if you are unable to identify the tainted, then you scrap the entire selection system. So in this case, they all were identified. He is one of those identified persons. His facts are slightly peculiar because of the fact that he approached the court and Ajay Chaudhary comes, but I will satisfy lordship on the entire thing. I will also satisfy that these judgments won't apply, but let my learned senior finish.
Yes. Well, just to respond to what my learned friend has said, my lord, that proposition that if you can separate the good from the bad, then save the good and discard the bad, that was a judgment in my lord Joginder Pal's case, that Punjab case. My lord, that was a case. In the first round, the matter was interfered by the Supreme Court. Then Supreme Court, my lord, remanded the matter. Pursuant to the remand, there was a 3 judges committee of the Punjab and Haryana High Court, which sitting judges, which went into, minute details, and they undertook an exercise where from they, my lord, they found out they are tainted, those are not tainted. In this case, who has undertaken that exercise? Well, it is a subjective satisfaction. You have lodged an FIR, somebody lodged an FIR, you are investigating that, you have filed a charge sheet, trial has not commenced. Trial is, I do not know what is it, comments, sorry. Trial has commenced, my lord. Now the question is, simultaneously you took disciplinary action, and midway you have aborted and discharged me. What is this? I can't be dismissed at your pleasure. I'm not holding any office at the pleasure.
You are not dismissed.
Discharged. Sorry, discharged. No, my lord, discharge, there has to be a good reason. I can appreciate, my lord, if my case is.
That's what I'm asking. Is it necessary that discharge of a probationer during the probationary period must be based on some reason? That's what I'm asking.
No, my lord. Law is like this in my humble understanding. Yes, there could be a case whereby a simple order of discharge, one can be, relieved. The idea is we are not, the intention is not to, impose any stigma so that you can get some other employment, etc., etc. Now, that exercise will undertake provided the records reveal that an exercise was undertaken towards my finding out my suitability, that whether I am good for the job or not, whether I am inefficient.
No, Mr. Chaudhary, let me rephrase it. I am asking a very pointed
No, my
question.
lord, I have understood. I am
I
trying to answer it.
Yes.
Now, your
Forget
lordship
your case.
No,
I'm
yes,
saying
lordship's
generally,
simple query is whether such an order discharge is, can be issued or not. Yes, it can.
no. The query is, during the probation period,
Yes.
if the employer wants to discharge an
Yes.
employee,
Yes,
is it necessary to anywhere record any reason?
yes.
Is it
No, my
the
lord.
law?
Yes, that's why. No, my lord, at least my lord, if nothing is passed, on what basis lordship will
No,
deduct
that's
this?
what I'm asking. Is it,
Yes,
this
it's
is
a
a,
requirement.
is it a matter of pure discretion of the employer or?
No, my lord, no, it can't be the discretion of the employer. My lord, employer can take an action only in the interest of exigencies of service. If the only way I can be discharged is if I am not suitable for the post or my performance is not to their satisfaction. But the moment they feel that I am, my lord, involved in some criminal case, that my entry into service is tainted, XYZ, in that case, my lord, the law is Article 311 will come into play, and you cannot pass this order of simple discharge on. That's my humble understanding. Now, my lord, I'll cite two more judgments. There are enough judgments. Next judgment is, my lord, 2010 8 SCC 220. 2010 8 SCC 220. I'll rely upon, my lord, paragraph 36, 37, and 45. This case is very important, man. This is Union of India versus Mahavir Singhvi. Now, at page, my lord, para 31, 32, and 33, lordships will find the judgments which were referred on behalf of the appellants. Then if your lordships would kindly come to para 37. Or I'll read para 34 also, my lord. In the two later cases, this court, relying on the principle laid down on Purushottam Lal Dhingra, reiterated the law that requirement to hold a regular departmental inquiry before dispensing with service of a provisional cannot be invoked in the case of a provisional, especially when his services are terminated by iniquitous order, which does not cast any stigma on him. However, it was also observed that it cannot be laid down as a general rule that in no case an inquiry be held. If the termination was punitive and was brought about on the ground of misconduct, Article 311(2) would be attracted, and in such a case, departmental inquiry would have to be conducted. My lord, there is no straitjacket formula which can be applied in every case. It will all depend upon the facts and circumstances of each case. Let me explain one thing, my lord. Why this power has been given to the employer? The rationale is, my lord, the employer, my lord, he must be possessed with some power. If supposing, my lord, an employee who has been selected and appointed on provision, his performance is not to the mark. Otherwise, my lord, and he does something which does not involve any moral turpitude, then you can discharge him. But the moment, my lord, the employer thinks that here is a gentleman, everything is okay, but he is involved in so and so, so and so, so and so. Better we not keep him. That he cannot do. That is the area.
Just 1 minute. RM does that matter, na? You know, ask them, all the councils to come at 1:15.
Now, my lord will kindly come to para 37. Appearing for the respondent, Jayan Bhushan Learned Senior Advocate submitted that contention art beyond behalf of the petitioners herein have been fully considered by the High Court, which said after considering the various decisions of this court, rightly come to the conclusion that respondent discharge from service was not a discharge simpliciter, but on account of several findings arrived at behind his back on the basis of complaints made relating to respondent's moral integrity. Then my lord may skip 38 and 39, 40 and 41. Mr. Bhushan submitted that the High Court had correctly held that order of discharge was only a camouflage, and in substance it was punitive order based on malafide consideration relating to finding of misconduct recorded against the respondent behind his back. Mr. Bhushan submitted that as has been rightly held by the High Court, the case of the respondent was fully covered by the series of decisions of this court, which have also been referred to on behalf of the petitioners. Bhushan, however, laid special emphasis on the following decisions of this court, some of which have been cited on behalf of the petitioners, namely State of Bihar, Shamsher Singh, Gujarat Steel Tubes, Anup Jaiswal, Nehru Yuva Kendra, etc., wherein it has been repeatedly observed that if a discharge is based upon misconduct, or if there is a live connection between the allegation of misconduct and discharge, then the same, even if couched in a language which is not stigmatic, would amount to punishment, for which a departmental inquiry was imperative. Various other decisions were also cited by Mr. Bhushan, which reflect the same views as expressed by this court in the above mentioned case. With the Lordship's permission, I would like to read Tacitum E once again, my lord.
Yes.
Mr. Bhushan, however, laid special emphasis on the following decisions of this court, some of which have also been cited on behalf of the petitioners, namely so-and-so, 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 wherein it has been repeatedly observed that if a discharge is based on misconduct, or if there is a live connection between the allegations of misconduct and discharge, then the same, even if couched in language which is not stigmatic, would amount to a punishment for which a departmental inquiry was imperative. Therefore, the law, as I understand, subject to what your lordship may say, is, my lord, first of all, even my humble submission would be, my lord, first and foremost, an order of discharge, which may appear to be prima facie or innocuous, is subject to judicial review. The moment, my lord, an order becomes subject of judicial review, then it is the duty of the respondent to place before this honorable court the record which will show the application of mind of the authority. The moment, my lord, the application of mind includes an element of some allegation regarding anything, regarding my conduct as an officer on probation, regarding my entry into service, then, my lord,
So
that
you are basically harping on this live connection between the order.
Yes, there is a live connection. I'll come to that, but there's an order of the single judge of this honorable court, why this is necessary. One more judgment. Finally, my lord, this Palak Modi's case, 2013 pre-SCC 607. 2013 pre-SCC 607. Now, I'll refer to 3 paragraphs, my lord. 36, 37, and 45.
36, 37, and 45.
And 45. The Supreme Court explains, my lord, what is the concept of satisfactory completion of provision and other aspects. Please come to page 633. There is a marked distinction between concepts of satisfactory completion of provision and successful passing of the training test held during or at the end of the period of provision, which is sine qua non for confirmation of a provisioner, and the bank's right to punish a provisioner for any defined misconduct, misbehavior, or misdemeanor. In a given case, the competent authority may, while deciding the issue of suitability of provisioner to be confirmed, ignore acts of misconduct and terminate his service without casting any aspersion or stigma, which may adversely affect his future prospect. But if misconduct, misdemeanor constitutes the basis of the final decision taken by the competent authority to dispense with the service of the provisional, albeit by non-stigmatic order, the court can lift the veil and declare that in the garb of termination simpliciter, the employer has punished the employer for an act of misconduct. So Lordships is empowered with the my lord doctrine of lifting of veil also to find out what actually had transpired. 37. The use of unfair means in the relevant test, confirmation test held by the bank certainly constitute a misconduct. The bank itself had treated such act to be misconduct. It is not in dispute that the services of the private respondents were not terminated on the ground that there was any deficiency or shortcomings in their work or performance during provision, or they had failed to satisfactorily complete the training, or had failed to secure the qualifying marks in the test held on so and so. As a matter of fact, the note prepared by the Deputy General Manager, which was approved by the General Manager, makes it crystal clear that decision to dispense with service of the private respondent was taken solely on the ground that they were guilty of using unfair means in a test held on so and so. To put it differently, the foundation of the action taken by the General Manager was the accusation that while appearing in the objective test, the private respondent had resorted to copying. IBPS had relied upon the analysis made by the computer and sent a report to the bank that 18 candidates were suspected to have used unfair means. The authority concerned then sent for the chart of sitting arrangement and treated the same as a piece of evidence for coming to the conclusion that private respondent had indeed used unfair means in the examination. This exercise was not preceded by an inquiry involving the private respondents, and no opportunity was given to them to defend themselves against the charge of use of unfair means. In other words, they were condemned unheard, which in our considered view was legally impermissible. Then my lord will kindly come to paragraph 45. The proposition laid down in none of the 5 judgments relied upon by the learned counsel for the appellant is of any assistance to their cause, which were decided on their own facts. We may also add that the abstract proposition laid down in para 29 in so-and-so is not only contrary to the Constitution bench judgment in so-and-so, 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 to which reference has been made by us and to which attention of the 2 judges bench does not appear to have been drawn. Therefore, the said proposition must be read as confined to the facts of that case and cannot be relied upon for taking the view that a simple order of termination of service can never be declared as punitive, even though it may be founded on serious allegation of misconduct or misdemeanor on the part of the employer. So, my lord, merely because the order recites nothing, and in effect, it is, shown to be an order, innocuous order, even that it may be a punitive in flavor, a punitive flavor, depending upon the attending facts and circumstances. Now, my lord, let us come
Chaudhary will
at 2 o'clock.
At 2 we'll continue.
Mala, I'll take another 15 minutes.
Mr. Das,
Lordship, I just thought as a matter of this, I am in difficulty after 3 because of my flight, but I'm here till 3. because of the traffic these days, I can make it even 3:30, but it's impossible to predict how much time it takes to go to.
Let us see, let us see.
My flight's at 6. I just thought I'll let Lordship know that. If required, then I'll seek the indulgence of a next day to conclude, if required.
All right.
That's all, Lordship. I'm so obliged.
Mr. Das, we'll need the record. You please get us definite information. What are the procedure adopted to with that notice? When can you get the record?
Lordship, I have, record has already been brought, Lordship.
Hmm.
This departmental staff has brought the record, Lord.
Then you examine the record and we'll take it up on day after tomorrow.
Lordship, can it be on Monday, Lordship? Day after tomorrow, I will be not available.
All right.
Monday. May I point out one thing, Lordship? May I point out one thing, Lordship? Till date, the department has not come up with the affidavit, Lordship.
No, those are, you argue when, now we are just fixing it on Monday, that's.
Lordship.
First up, my lord, I have taken your lordships to the facts, then before case laws.
Tax lie in a very narrow.
Very
campus.
narrow. Simple fact, my lord, there was an affair, there was a police case registered. Following my lord, investigation charge sheet filed. Then that has not gone beyond that.
Your client is not named in the FIR.
It's named. No, my lord. Yeah, I'm named. Even in the charge sheet also I'm named. I'm not on that. Question is, my lord, the moment you take note of anything which is connected to do with some wrongdoing on my part, then you cannot take resort to Rule 21. That is the basic argument. Now, my lord, this honorable court on 22/9/22 had passed an order. In this case, please have a look at that.
Yes. Yes.
Now, my lord will kindly come to paragraph number 8. Sorry, paragraph 7 and 8. In fact, this state's stand was made known by my learned friend, my lord. Mr. Nalin Kohli, learned senior additional advocate general Assam, refers to provision of Rule 21 of the Rules of 80, and by referring to the said rule submits that it is permissible for the authorities to discharge a temporary or officiating employee if either of the two conditions provided in subclauses 1 or 2 are satisfied. According to Mr. Kohli, in the instant case, subclause 2 would be attracted and accordingly seeks to justify the order dated 31/12/21. In order to appreciate the rival stand, we are therefore of the view the records which may contain the materials the respondent had in order to arrive at their satisfaction, the requirement of 21(2) of the rule was present would be required. So, my lord, this honorable court wanted to have a look at the records. Now, please come to Rule 21, which we have quoted in the petition, my lord, at page 22. A temporary or officiating member shall be liable to be discharged or reverted to the lower grade of service or to his original service if he fails to make sufficient use of the opportunities given during any training as may be prescribed by the government from time to time, or fails to render satisfactory service during his tenure of service in the cadre. 2, if it is found on a subsequent verification that he was initially not qualified for the appointment or that he had furnished any incorrect information with regard to his information. Now, my learned friend, as a senior law officer of the state, my lord, had made a submission which was recorded in the order that state had taken recourse to sub-rule 2 of Rule 21. Now, if we literally try to find out the meaning of sub-rule 2, it is, my lord, that on subsequent verification, it so turned out that some information given by him is not correct or that he was not qualified to hold the post. My lord, this satisfaction that there is infraction of Rule 21(2), it must be based on some objective material. Which is that objective material? The police report, the charge sheet is not, my lord, objective material. That is for a particular purpose. And Lordship knows in the criminal jurisprudence, my lord, I am presumed to be innocent until I am proved guilty. So today, my lord, there cannot be even presumption of guilt also. Tomorrow in the trial, if my lord, the prosecution establishes the case that yes, I got the job by paying money to Mr. Rakesh Paul, then yes. Until that stage is reached, which is that material which impelled the government to take this decision. Number one, in any case in a statutory jurisdiction, my lord, respondent is bound to produce the record based on which, my lord, the satisfaction is derived. Now, my lord, so the moment we come to this portion, this angle, my lord, the consequence which flows therefrom is that means some misconduct was taken note of, some wrongdoing on my part was taken note of. And if that be so, my lord, then Article 10(11)(2) stands effect. In this case, my lord, they ought to have done some inquiry or some, inquiry consistent with the principles of natural justice.
So, Mr. Chaudhary, in other words,
Yes.
had they not served you with the memorandum dated 24/5/2021,
Yes.
the entire plank of your argument would have been
Different.
non-existent.
Yes.
Different means in today's
Yes.
context, non-existent.
Yes. So, my lord, it can't be.
You are saying they have shot in their foot by giving this charge memo? Is that what your argument is? You have to meet it.
Broadly, Lordship, I would say has put it very succinctly. I mean, as an officer of the court, I think that's the crux of it. That because there is this charge memo, therefore the circumstances may be different. I will, of course, satisfy Lordship on all of it after my
No,
learned
my lord, therefore, my lord, the perusal of the record would be very crucial in this case. To arrive at any way, my lord, this way or that way, my lord. But as far as I am concerned, my lord, representing the petitioner, my basic argument is number one, this is not an innocuous order of termination, though the language appears to be very innocuous. In effect, it is a punitive order. The reason being, they have taken note of the allegation in the affair, and that is the foundation. And my subsequent arrest because of my alleged involvement in the criminal case. My lord, in the APS and ACS officers case, they made a mistake by mentioning that it was the police report which impelled them to do so. Here, of course, they have not said so in their affidavit. But my lord, they will have to show why Rule 21 had to be invoked. It can't be in thin air. There must be some material to show. So, my lord, to summarize my argument, therefore, number one, it is a punitive charge. Therefore, principles of natural justice or principles akin to Article 10(11), my lord, violated. Secondly, my lord, to derive at the satisfaction, there must be some material. Now, the question is now from the affidavit, it is not discernible. So, the records will reveal what are the materials. It can't be that there are no materials, yet they passed an order. Therefore, my humble submission is, my lord, it's a clear case of violation of Article 14 and 16. Because, my lord, equality of opportunity has not been extended to the petitioner in as much as 311 or the principles akin thereto which is applicable has not been applied as it is.
No, but Mr. Chaudhary, just one question here. I have understood your case. The reliance placed in the 2010 judgment or 2013 judgment.
Life connection.
Live connection. You see, what really is the allegation against your client in the charge memo? Would you please read the charge?
Yes.
What is the allegation?
Yes. My lord, charge memo, please come to 125. That's the para which has been attributed to us.
125.
Yes.
Yes.
Para 16.6. During the course of investigation, charge sheet was submitted against arrested accused Mrigan Haloy. Statement of witness recorded under 161.
No, you are reading from the charge sheet.
125, my lord.
Charge sheet submitted in the criminal case.
Yes.
I am asking you, what is the charge in the memorandum of charge?
This is the charge, my lord. I am reading the charge sheet.
This is the charge sheet in the criminal case.
Oh, in this charge sheet in the disciplinary proceeding?
Yes, yes.
Oh, that is, I am only arrested in a criminal case. Nothing else. That is at page 107.
arrested in a criminal case.
Yes, yes, that is the only chance. I guess the reason. 107, my lord. Charge. While you were working as ADO, Bangtol Sirang, you were arrested by additional superintendent of police so in connection with so case. In so and remained in police custody beyond 48 hours. You were therefore charged with gross negligence. This is the charge.
This charge is somehow, Mr. Kohli.
Lordship, I have lots to say, but I'm waiting for him to finish.
No, but what is this?
Even
charge?
this Lordship, this is much later. Therefore, I'm going to come. I will satisfy Lordship on every count.
No, that's all right. I'm asking, what is this charge?
Lordship. So that's why I'm saying, Lordship, I'll have to start with my preliminary and come here. I'm not going to run away from the file or anything like that. I'm here to assist Lordship in totality. But let my learned senior.
I have concluded, my lord. I
Right.
reserve my right of reply.
Of course.
Otherwise, I'll be repeating the same thing. Why should I take your valuable time when I can conclude within the.
Yes, yes.
That's my humble submission. Therefore, my lord, it's a fit case where lordship will interfere with the order of the charge. And it is open to them to conclude the disciplinary proceeding in accordance with law. Even the learned single judge of this honorable court gave them the liberty, which they did not took forward. That is my humble. Lordship's kind permission is another matter. Deeply.
Lordship submission. Let me, Lordship, start with 3-4 random comments to what my learned senior had argued on Article 14. And I will argue exactly using Article 14 that this is an identical case to everyone else who has been discharged, that a coordinate bench of this honorable court passed a detailed order looking at the entire law, facts, circumstances, all materials, each and every file. No stay was ever granted against their discharge then, the other petitioners. In appeal, no stay till today. Now, what are we talking about, Lordship, essentially, is the APSC scam. And when that para 8 is quoted, that is one argument of the many arguments I have here. So, Lordship, for me, it's almost deja vu. Because all these very points, these very judgments, the very foundations of these arguments have been placed before the learned single judge, duly considered, and I will show that, including Palak Modi, and which today is in appeal. Lordship, there is basically misconduct word came up again and again. And the learned single judge at the coordinate bench in that judgment has also considered the reverberation of this word misconduct and rejected it. Because, Lordship, we are talking of two separate sets of circumstances. A person with a bona fide entry into the service, with no taint for entry into the service, then during discharge of his or her official duties, faces a situation that calls for some misconduct or inquiry, and therefore Article 311 kicks in. Versus a separate situation where the very entry into the service is fraudulent, tainted by a colossal fraud. And this petitioner is identically placed, same set of allegations, same set of batch as the others who were discharged. The difference being, Lordship, and I only can say it happens in the government, he miraculously remained off the radar. Why? I don't know. And also it's not my remit. And then, Lordship, there is this attempt by a set of these petitioners, we've seen it as a pattern over 3 years. May I put this off? Or it's okay. That, Lordship, they will come with a selective set of facts, seek the equitable jurisdiction, the magnanimity of this court, get an order in a context, and then use it to benefit otherwise, which is what I would say, where does Ajay Chaudhary even apply? His entry is tainted. So, Lordship, let's come to the case itself. Just 3 or 4 facts from his file before I start making the submission. and they are relevant. Let's see his appointment order at 58. 58, Lordship, of the petition.
Why do you allow sound to? Page 58.
Yes, Lordship. His appointment order. The most critical word which needs to be pointed out in that order. My voice is normally booming.
Yes, it is, but we are in live streaming,
Then we should.
so people outside may not be,
Yes, of course.
your voice will not reach.
No, Lordship, I am not the voice that there was the word.
Yes, yes.
The Lordship may just note the order of 26th February 2016, and Lordship may come to the third last line where Governor of Assam is pleased to appoint the following persons as agricultural development officers, ADO. Lordship may mark the word temporary. This is the critical word.
Yes.
Lordship, his name is there, so I'm not going to further, but he's temporarily employed. And for a minute, Lordship may come to 121, which is his discharge. And Lordship may, on page 121, annexure 21, also note after his name at Bengtol Dirang, temporary as well as probational. Page 121. 121. Temporary. He is a temporary employee and probationer.
Yes.
Now, one of our arguments, Lordship, was under the General Clauses Act, the power to appoint also includes the power to suspend and to discharge. So now, Lordship, returning back to this, for a moment we'll go, Lordship. The FIR has already been read. There were allegations. What was the APSC scam? Lordship would know, but in 3 sentences. That here were a set of people who, in connivance with, or let me reverse, the APSC chairman, in connivance with permanent employees of the APSC, and that's very critical, acting as his tout, approached candidates who were keen to enter into service, and this is public service, public office, paid large sums of money. In his case, it's, I think, 10 lakhs, but goes up to 15, 20, 25 lakhs. This was revealed by an informant, and there was a massive investigation. And the massive investigation revealed the modus operandi, which was exceptionally well crafted. What was the modus operandi? That those who paid the bribes to the detriment of the other candidates, and Article 14 is used, to the detriment of other candidates, their papers were replaced in the strong room. This was the basic modus operandi. They paid the amount. On a subsequent date to the exam date, rewrote the paper because the main accused, the chairman of the APSC, his brother was running a press where the duplicate papers were printed. Forensic revealed that the invigilators' signatures never matched. The handwritings of the people matched, or others like him manipulated the marks, depending on the service. And the price was essentially, which is the service, being ACS or APS or taxation, etc. When this scam came out, the question that came before any government was, do you cancel the entire examination and selection, or do you go for those you have done an investigation on? Since it was a massive investigation, there were 52, if I recall, identified candidates through forensic, etc. The government decided and preferred to go for their discharge. Now, Lordship, including Kehlo, because I'll be relying on a series of judgments, or Joginder Pal, all of it, the law of the Supreme Court is absolutely unequivocally clear. If you can segregate the grain from the chaff, which is the tainted, can be segregated, do not cancel the exam or the selection, because then it is to the detriment of all those who bona fide, in a bona fide manner appeared. However, if the scam or the fraud is so large that it is not possible to segregate who are the tainted, then scrap the exams. This has been consistent. I would respectfully say that this honorable court in that judgment dated March 2020 has not only considered the entire law right up to the point of the judgment, but in fact gone on to further from para 46 onwards, pen down this circumstance and making that making that argument of holding that misconduct has to be for a applicability of 311 for a bona fide entry. It cannot be, you can't seek the service rules to apply to you if your entry is fraudulent. You can only seek that if your entry is bona fide. And then the next question comes, Lordship, which is when anyone invokes the writ jurisdiction, it's an equitable jurisdiction. The question that has to be seen, respectfully and humbly I would put, is what is the public good in the final outcome? And is it serving the public interest or a personal interest? The writ jurisdiction cannot serve a personal interest. It can merely serve the public interest, and there's law to that effect also. Now, Lordship, having seen this, two more documents in his petition. Lordship may just come for a moment to the bail order, starts at 75, Lordship. And we can go straight, Lordship, to 77. Where at the bottom of the page 3 of the order, page 77, Lordship, the findings start.
Yes.
I have carefully seen the rival submissions, Lordship. The second last paragraph. We may turn the page, Lordship, to 81. Where I have only 3 paras to read, page 81.
Yes, please.
Page 81, Lordship. I have gone through the order dated 18/6/2019 passed by the Honorable High Court in bail application number so-and-so, wherein the Honorable High Court rejected the bail application of the accused petitioner Mrigan Holloway on the ground of non-completion of investigation. However, as discussed above, thereafter the IO completed the investigation in respect of accused Mrigan Holloway and submitted charge sheet dated so-and-so. He's charge sheeted. I will also, Lordship, show one of the judgments considered by the Honorable Single Judge, which is that the police report is enough. In one case where the CBI was there, in fact, that judgment goes to one step further. Says the police report is enough for discharging people like this who are tainted from public service. And normally we should disgorge them of the salaries that they have already taken till date. But we are refraining to do so. That's a Supreme Court judgment. Then leave the next para, Lordship. The third is accused petitioner Mrigan Holloway, who is a beneficiary of the illegal racket. I am just, Lordship, emphasizing this finding by the court while granting him bail has not been challenged by him till date. Accused Mrigan Holloway, who is a beneficiary of the illegal racket, in my view, cannot be equated with the main kingpins, the chairman. But this finding on merits stands as it is today, and then he's released on bail. Now, Lordship may come to 112, which is his response to the show cause notice. I have something interesting to point out there.
Yes, 112.
Yes, Lordship. His response to the show cause notice. And the relevant part is at 114, Lordship. I will be reading para 4A. May I read, Lordship?
Yes, please.
That in the contextual facts relating to the APSC's cash for job scam, I beg to state as follows, that it is needless to say that all employees under, and note, all employees under the government of Assam are uniformly covered by the Assam Service Rules of 64. In other words, the government of Assam being the employer, all its employees, irrespective of departments, comes under the purview of one uniform yardstick in matters of disciplinary proceedings. Now, one of the accused in the alleged scam, Nabakanta Patil, who was something stayed in judicial custody beyond 48 hours. But it continues a little later. However, in the said departmental proceeding, the government of Assam wide notification so-and-so has been pleased to reinstate Nabakanta Patil in service. Lordship may pause. Apples and oranges being compared. Nabakanta Patil is a permanent employee. He is not a temporary or probationer. That's why, Lordship, I said selective use of facts and invoking selective principles of equity. The full disclosure should be there if one is invoking the magnanimity of the court under the writ jurisdiction. Selective facts cannot come. It's a full disclosure. Nabakanta Patir, as the next name, which I will point on the next page, are permanent employees, not temporary or probationers. Now, Lordship, the Article 14 is invoked. Qua a separately placed person, why should Article 14 not be invoked for an identically placed beneficiary of a colossal scam? The state, I would argue, is obligated to act equally against all those equally placed. Next page, Lordship.
Yes.
That apart, the another accused in the scam, namely Syed Musharraf Hussain, stayed in judicial custody beyond 48 hours, was reinstated. Same, Lordship. He's a permanent employee. Now let's go to the next para, Lordship. See that considering the fact I am also a government servant, not a permanent employee versus a temporary probationer of the same government of Assam, who was taken into custody on mere suspicion, your good office may be pleased to treat me similarly with the above named accused persons, government servant, by bestowing similar relief to me. Lordship, as a probationer who entered the service through a fraudulent process, a tainted process, is a beneficiary of that fraud, is making an unequal comparison with a confirmed employee who did not commit a fraud to enter into the service. This is not a case of misconduct after a bona fide entry into the service. I've said that. The question which I keep asking myself is, should the state not be obligated to act equally against another probationer temporary employee who, in an identically placed situation, came on the same facts? Lordship, all these pleas of Nabakanta Patir, of Syed Musharraf, have been rejected, considered rejected by the learned single judge of a coordinate bench.
Is that a reporter judgment?
Yes, Lord.
What is the citation you brought it?
Yes, of course, Lordship. It is. Can you give the citation?
Yes.
It's a beautifully.
It's reported in 2020.
Right.
Field jail.
Can you just pass over the book
Yes.
for 2 minutes?
Yes.
Mr. Kohli, I'll just give me 2 minutes to.
If Lordship was, I have also quoted part of it, but para 46 onwards is very, very.
Only, my lord, in that case, it was Dibrugarh PS case number 936. In this case, Bhanagar PS case number 159.
Separate FIR, same scam. Huh?
So this judgment covers this case then in that case.
Well,
what
it
is
covers
that?
all the similar facts except the petitioner. That's the only difference.
The principle is
Identical.
appeal has
It's
been
pending.
dismissed.
Pending, no stay.
Division bench dismissed the appeal.
No, Lordship, it's pending. Actually, we've had change of Lordships or the Chief Justice Lordship. So they had moved Lordship for an interim stay. The application for interim stay was duly considered and rejected by the DB. Thereafter, final adjudication is pending. But the judgment holds the field.
That's right. So perhaps the central issue is covered by this judgment.
Lordship, my argument is not just the central. This is an identical case minus this one, if I call it aberration. In fact, Lordship, I didn't want to say it, so it's not a submission. As an officer of the court, when this matter came to us, and I'm therefore not making a submission in Delhi from the agricultural department, because suddenly the government found, how did he escape the net? So we had called for everything, Lordship. The secretary came, an officer of the department came. And it was inexplicable to us for what reason. While this was parallelly being heard, the main batch, his case and all his writ petitions are running parallelly in the same court. Nevertheless, Lordship, again, not as a submission, eventually one of the two people who met me was arrested for a bribe in a separate matter. I just therefore say that, Lordship, he miraculously escaped the spotlight. And Lordship, if one sees one's conduct, it is in the next paragraph of page 115. He says, keep it all in abeyance till my criminal outcome is there. In his own show cause notice, against the direction of this honorable court, early resolution. That's why, Lordship, how they misuse the writ jurisdiction. Of course, on merits, I will speak a lot in terms of the judgment and other things. And Lordship, this is without prejudice to the fact that even his acquittal in the criminal proceeding will have nothing to do with his discharge, because the law is on that clear. Which is Krishan Yadav's judgment, which is one of the relied judgments and considered judgments by the learned single judge.
So, just to interrupt you a little, Mr. Kohli,
Yes.
would you like to read para 46 of the judgment first?
Lordship, it's in, yes.
And then we'll proceed. Then we'll
Also,
continue.
Lordship, in fact, 46 to 48 is also in my petition answer, in my reply. I'll just show it. But 2 minutes, Lordship, one thing on that one page, then I'm done with this booklet. If Lordship would be just indulgent on page 115, which is para 5. And then I'll come straight to that, Lordship.
Yes.
That alternatively, I humbly pray to keep the present proceeding in abeyance, as the charges leveled, including the materials relied upon against me, are identical. He himself is saying identical to with the charges in the criminal proceeding. And as such, if I disclose my defense in the proceeding, the same will cause me prejudice. Lordship may come to page 89, which is the order of this honorable court when he invoked the writ jurisdiction.
Page 89.
89, Lordship. That order starts at 85, Lordship. But the relevant paragraph 18, which my learned senior had read and emphasized, the order starts at 85, Lordship, para 18. However, it is made clear that the respondent departments may initiate the disciplinary proceeding against the petitioner in accordance with law and to complete the same at an early date, with further observation that the petitioner shall participate in the same towards its early completion. See the conduct, Lordship. He takes this indulgence from this honorable court and then says, keep it in abeyance, which without prejudice to the argument that Krishna Yadav says, acquittal will make no difference, because police constables also have been discharged on the basis of a fraudulent entry into service, or in that one particular case, having links with terrorists. Lordship will come to para 14. I'm, Lordship, reading it from my
Yes, please.
reply, Lordship. So, Lordship, para 46, clearly, the allegations of irregularities on the part of the petitioners are not allegations of any irregularities, negligence, inefficiency, and misconduct taking place during discharge of their duties post-recruitment or after having been appointed to public offices. The post-recruitment, the allegations against the petitioners in indulging in gross irregularities and fraud, there's a finding of fraud involving payment of illegal gratifications for securing appointments to public offices are patent apparently of pre-recruitment period, that is before they were appointed to public offices. In the understanding of this court, the element of misconduct which reverberates in the submissions made on behalf of the petitioners is attributable only in respect of a period subsequent to a valid initial appointment. Not a single citation could be placed on behalf of the petitioners for the proposition that irregularities committed during the recruitment process and or before appointments have been made and or before a person is born into the cadre or service would constitute misconduct. The same judgments. Now, Palak Modi. A vain attempt was made when reliance was placed on paragraph 37 of Palak Modi to say that the use of unfair means in the evaluation test, confirmation test would certainly constitute misconduct. Reliance so placed vis-a-vis the facts and circumstances in the present cases is altogether out of context. Thus, para 37 of Palak Modi, which makes mention on the use of unfair means during evaluation test, confirmation test would constitute misconduct, was only in respect of test conducted for the purpose of confirmation in service. No law was laid down in Palak Modi that misconduct can also be stretched back to a period prior to entering into the service and for illegalities and irregularities committed during the selection process, as misconduct cannot be a pre-recruitment phenomena. The very bedrock of the submissions made on behalf of the petitioners, that the impugned action being founded on misconduct, therefore the principles of natural justice and or the provisions of Article 311 of the Constitution could not have been dispensed with, in the considered opinion of this honorable court, it does not hold any water. Para 47. Indeed, there can be no hiding from the fact that the arrests and the materials collected against the petitioners following the FIR dated so and so in Dibrugarh, and as my colleague pointed out, this is the Bhangargarh case, so there were 2 FIRs, had set the ball rolling. The investigation reports of the Dibrugarh police were the foundational facts, the gravity of which was considered by the government of Assam in the Personal Aid Department, which eventually resulted in the impugned orders being passed, preceded by consultations with the departments, obtaining the views of the Judicial Department and with the approval of the highest governmental authority. The impugned actions are only in respect of an identifiable group section of candidates who had appeared in the main exams. The identifiable group are only those candidates with their duplicate answer sheets after substituting with their original answer sheets were recovered from the confidential examination branch of APSC as well as from the house of the then chairman so and so. This identifiable group alone was discharged from service and against whom charge sheets have been filed. He is identically placed. Investigations have revealed that the petitioners had indulged in unfair means for getting selected by paying bribe or on extraneous considerations, but certainly not on account of merit. There are cogent materials on which the respondent authority derived satisfaction that the selection process through which the petitioners came to be selected and eventually appointed was tainted by fraud, and fraud unravels everything. Irregularities in the selection and appointment of the petitioners being found at the threshold itself, can it be said that the state action was not bona fide in discharging the petitioners from service? And was it not their solemn duty of the state to take the impugned action for maintaining sanctity and in reposing faith in the system and public offices? In relation to the affairs of the state government, can it be said that it is not open for the state government to act on the disturbing revelations emanating from the police investigations with regard to grave irregularities being discovered involving the petitioners during the selection process, which illegalities occurred well before they had entered the service? To reiterate, the discharge of the petitioners from service was not on account of any alleged misconduct after appointment, but on discovery of fraud at the point of their very entry into the service. There is a clear dividing line between the challenge made to an order of discharge on grounds of misconduct during post-recruitment period and a challenge made to an order of discharge on grounds of irregularities and illegalities finding place relatable to a pre-recruitment period. Very, very clear, Lordship. Lot has been considered. That's why I said deja vu. Whereas the former would invariably invite compliance of the Audi Alterum Partem rule of natural justice and or compliance of the protection guaranteed under Article 311 of the Constitution, the latter can fall within the category of exceptions to the rule of Audi Alterum Partem, particularly if the reliable materials to reach the satisfaction that, insofar as the petitioners were concerned, the examination process and their selection was vitiated. Going back to Parshottam Lal Dhingra and Shamsher Singh, relied upon, Palak Modi, Palak, all of this. It is only when termination is seen to be founded on manifest misconduct, it would be a punishment and will go to violate Article 311 of the Constitution in the absence of any inquiry. However, as observed above, the arguments on misconduct being the foundation are wholly misplaced and misconceived, inasmuch as the discharge of the petitioners from service are not founded on a phenomena of misconduct as is understood in service jurisprudence. Para 48. The Dibrugarh police reports following investigations are part of the records, and a compilation of the same has been furnished before this court by so and so during the course of the hearing. It is seen that the irregularities and illegalities discovered in the selection had been scrutinized and investigated upon in respect of each of the writ petitioners. For a moment, Lordship, every file was perused. Every. The detailed police investigations enabled to pick out the candidates who had unlawfully benefited. A mere perusal of the police reports leaves no room for doubt as to the thoroughness with which the investigation was carried out. Irregularities attributed against each of the petitioners are minuted, reinforced by statements made before the investigating officer by such petitioners as available in the records, admitting to their complicity. Having gone through the police reports, the prima facie view of this court is that the same commends itself to acceptance. The question is, could such selection in respect of the petitioners be acted upon in matters of public employment? May I continue? Also, whether the state respondent could have acted upon a police reports to eventually discharge the petitioners from service. This is also being considered. That can only that be the basis. No law is cited on behalf of the petitioners to support a view that there is a legal embargo in acting upon police reports, as is seen to have been done in the present cases. On the contrary, and I mentioned these judgments, The decisions in Krishan Yadav and O Chakradhar goes to support a contention that police reports can be acted upon. This court therefore would hold that the orders of discharge, which are the subject matter of the challenge in the present cases, do not suffer from any legal infirmity, only on a contention that the impugned orders are based on foundational facts emanating from the reports of the Dibrugarh police. Rejected that. Orders of discharge from service founded on police reports are one thing, and orders founded on misconduct are altogether a different aspect of proposition. What is relevant in the present cases is to ascertain whether the orders of discharge were founded on misconduct as understood in service jurisprudence. This has already been answered in the negative in the preceding paragraphs of this judgment. In Inderpreet Singh Kehlo and Joginder Pal, which were those judgments, the Supreme Court had dealt with two categories of candidates who had been selected to the executive post through examinations conducted by the Punjab Public Service Commission. They were categorized as tainted and non-tainted candidates. Taking a cue from Inderpreet Singh Kehlo, this court would hold, so takes it further. This court would hold that if services of appointees are to be terminated after having put in a few years of service, what would be imperative are the sufficient materials that have been collected on the basis of a thorough investigation in a fair and transparent manner. And the illegalities committed have gone to the root of the matter, vitiating the selection of the appointees, and that the appointees must be found to be part of the fraudulent purpose, and or the system itself must be found to be corrupt. Applying the above principles, there is no denying the fact that against each of the writ petitioners, sufficient materials have been collected through a process of a thorough investigation, and the materials so collected disclosed grave illegalities and involvement of the petitioners. The gravity of the illegalities found to have been committed was such that it had gone to the root of the matter, thereby vitiating their selection. In Joginder Pal, in respect of the petitioners therein, who were found to be tainted candidates and were facing criminal trial, the Supreme Court held that the fate of such candidates do not pose much of a challenge, as it was found that they had indulged in unfair means and were selected either by paying bribe or because of such extraneous reasons, certainly not on their merit. This is precisely the case of the writ petitioners herein, as revealed from the police reports. Para 50. On the foundational facts and the consequences of law impacting on the petitioners would brook no exception. Manifestly, the petitioners cannot be regarded as innocent or too immature to understand the consequences of their actions. The materials collected through the process of a thorough investigation reveal that the petitioners were clearly amongst the identified segregated beneficiaries of an illegal process. The process is illegal. The petitioners who have been identified as having indulged in illegal and unfair means of selection, either for making illegal gratifications or because of extraneous reasons and not on account of merit, this court would take a position that the decision to discharge them from service is perfectly justified. This court would not accept any contention that as there may be a possibility of acquittal in the criminal case, therefore the decision to discharge them from service at this stage was not warranted. Relying on the observation made in Joginder Pal, the petitioners cannot be heard to say that they should be reinstated in service and allowed to continue until decision is rendered by the competent criminal court, which is what he has done in his reply to show cause notice. Para 52. 3 more paragraphs. Yeah?
Yes, please.
Thank you. So, on the above, first and foremost, the circumstances resulting in the discharge of the petitioners from service are undoubtedly exceptional. Sham examinations involving the petitioners in the mains examinations and their selection and appointment through an illegal process is the basis of their removal. The foundational facts, as observed in the preceding paragraphs in the opinion of this court, was sufficiently compulsive to take the petitioners out of their jobs. There was need to promptitude in taking stringent action. However, when it involves discharge from service not founded on misconduct but on grounds of grave illegalities and irregularities, as indulged by the petitioners at the point of their selection and prior to their entry into service, there cannot be a contention of infliction of civil consequences. Even Menka Gandhi had been considered. Section 16 of the General Causes Act, I have already said that, Lordship. Then para 55. It goes from general clauses and Tulsi Ram, but we have dealt with that. The arguments placed on deemed confirmation in service, either on account of having completed the initial probationary period of 2 years in some cases, or due to names of some of the petitioners appearing in the final gradation list, or the word probation not being mentioned against their names in some official documents, or the second increment having been paid to some of the petitioners. All arguments were professed. Which increment is allowed only on confirmation service in terms of Rule 25 of the 1998 rules. The fact remains that there are no orders passed by the competent authority in respect of any of the petitioners towards confirmation of their service. He was temporary and probationer. Law does not permit automatic confirmation in service due to a flux of time unless the service rules governing the servant specifically lays down that condition. There cannot be any question of deemed confirmation merely on the ground of continuation. So this whole thing is on deemed confirmation, para 56. For all the reasons and findings above, the writ petitioners have failed to make out a case warranting interference to their impugned orders of discharge from service. The petitioners are not entitled to any equity, and the foundational facts alone speaks volumes of the irregular and unfair procedure that had been set in promotion and process to reach its illegal goal, which process have found the petitioners to be in direct beneficiaries. Before parting with the case, this court would also record that the judicial conscience must only support the righteous cause. Grant of any relief to the petitioners in the opinion of this court would only act as an anathema to the righteous cause. And Lordship, that is
So
what...
in this batch of petitions, the grains and the shafts were together,
Yes, Lordship.
not separate.
So Lordship, I must, because I have to assist the court as an officer, so I may just take a moment. So Lordship, the investigation revealed some 52 people. They were all discharged. That was the batch which came on in the appeal before the learned Honorable DB. Not all have challenged it. I think some 5-7 haven't. Now, Lordship, subsequently to that, parallelly, there was a Justice B.K. Sharma committee report also that had come. And that committee report, of course, what has been said was that it should go and discharge the entire, as in basically scrap the entire process. Then a committee was formed by the government of Assam under the chief secretary. I am also a member of that committee. And that committee, of course, decided to go further into the materials. But broadly, what I assisted that committee and pointed out is that the law of the Supreme Court is very clear. If you have done a thorough investigation and identified the beneficiaries, then you only discharge them, which is clear, which is even the Joginder Pal Singh's judgment with Justice Sikri is the last in the series, clearly. And these were identified because scrapping it causes civil consequences to those who entered bona fide. That was one. Second, Lordship, again, respectfully, which I raised in one of the committee meetings, is that ultimately, this honorable court has passed a judgment which holds the field today on looking at all of this, including the argument of whether it should be scrapped. Because the APSC had rocked the state and different PILs had come on also. Out of the PIL, CBI was also there. A lot of things happened, Lordship. It rocked the judicial conscience, it rocked the conscience of the administration, it rocked the conscience of people and their faith in public office. So something had to be done. So when the court has, which is this court, a constitutional court, gone through the entire exercise in detail, considered all the arguments, all the judgments. In fact, I would be only relying on the very same judgments that the honorable single judges relied. Krishan, Yadavo, Chakradhar, all of them. All. Because all this has been, that's why I started by saying in my respectful submission, 4 things. The first, Lordship, it is squarely covered by the judgment of 18/3/2020 by the coordinate bench. There is no stay on that judgment. It is pending adjudication with the DB. That judgment upheld the identical discharge orders against some 52 people. Identical discharge orders of such temporary and in fact, some of them don't even...
Only difference is that was Dibrugarh police case, this is Bangalore.
Right, Lordship. But the entire modus operandi, everything, Rakesh Paul was eventually arrested in Bangalore. So Lordship on that also to assist Lordship only. He was getting the benefit of this, default bail in the Dibrugarh. At that time, Bhangagarh had come out. He got arrested in Bhangagarh. For 6 years he stayed in. Lordship, it has gone to the Supreme Court at least twice. I have stood there. And I have seen how the Honorable Supreme Court looked at it, that we public officers and their sanctity has to be maintained. No indulgence. Finally, of course, I think, because I think his total period is, I think, 8 to 10 years. He has spent more than 6 years. Recently, I think Guwahati High Court has given bail. Now, Lordship, the third point I was saying, the appointments per se are void ab initio. If your entry is fraudulent, tainted, you cannot claim the benefits of service law and service law jurisprudence and the rules. You are a separate category, which is being dispensed with. You can't make a comparison with a permanent employee whose entry is bona fide.
No, that point is noted. You have argued that.
Then Lordship, 3 more points, which is, what is his right to continue in public office? On what basis is he claiming a right?
No, Mr. Kohli,
Lordship.
if I have understood correctly,
Lordship.
it is not about a question of right. What Mr. Chaudhary was arguing is
Lordship.
the procedure followed
Lordship.
in this case. And his argument essentially is that he is entitled to the protection of the principle of audio alteram partem.
Right, Lordship.
Since you have come up with an allegation against him, which has got a live link
Yes, Lordship.
with the, therefore his order of discharge has a live link with the allegation. And
I will
but
answer.
then that is before this judgment was placed before this court, where the learned single judge has made a clear
Yes,
distinction,
Lordship.
2 compartments. Irregularities at the entry stage and misconduct in service have been held to be 2 different chapters altogether.
Right, Lordship. 3 things to this I must point out. Number 1, the police report being the foundation of a discharge has been considered by the Supreme Court. That is the law.
Yes,
It's
sir.
considered.
Yes.
Number 1. Number 2, Lordship, is the theory of empty formality, which also has been professed before the learned single judge. That you don't go for the empty formality theory, which is if we know what the outcome is to be, you don't do it. His own conduct in his reply is in contravention to the solemn direction by this honorable court for an early hearing. He says, keep it in abeyance, compares apples with oranges. 4th is the next principle. This is public office, public trust. And whatever be it, the court process of the court, respectfully and humbly, I would say, is finally for looking at the public good. And that's why I use the argument, there is no infraction of a fundamental right, much less a right. There is no infraction of a right, much less a fundamental right. Because after all, we are in the writ jurisdiction, Lordship. And Lordship, their latest judgment of Justice Chandrachud, which is, I will give a copy, Lordship, which was not considered at that time, is the 2021. Yeah. So, but Lordship, on that also, I can take the law on the next date if Lordship so wishes me. But just to point out.
No, you will take it on the next date and it will be a pleasure to hear arguments from both of you. But what I was asking is, this is a covered case, Mr. Chaudhary. What is there?
Let my learned friend conclude. Just take 10 minutes to say why it is different. My lord,
Then-
it's a fact, there is a judgment by learned single judge of this honorable court.
May I with Lordship?
If learned single judge manifestly commits a mistake, my lord, in the judgment rendered by the learned single judge has taken note of Palak Modi and to say that if any irregularities committed at the time of entry into this service, if those allegations are taken note of, it will not constitute misconduct. For a moment, if you lost, I'll just read that matter. I think that is the core of my learned friend's argument.
No, all right.
I'm just placing my lord.
I don't want to disturb your.
No, what I'm
Read up.
saying is, since your lordship has, I mean, that's the core of the issue. That's why I thought I'll just give a
All right.
1 minute reply. Not at paragraph reading 46, my lord, of the learned judgment. Not a single citation could be placed on behalf of the petitioner for the proposition that irregularities committed during the recruitment process and or before appointment had been made or before he is born into a service would constitute a misconduct. In other words, what on the learned single judge held in this judgment is, my lord, that the judgments which have been cited at the bar, these are all judgments pertaining to a stage when one has become a public servant, he has become a government servant. So in that stage, the law has to be construed separately in a case where the allegation is his entry itself is tainted. That's the argument. Now, my lord, merely because there is a single judge judgment, lordship will not shut the eyes. What Supreme Court says in Palak Modi, para 37, the use of unfair means in evaluation test, confirmation test held by banks certainly constitute a misconduct. Then the basis of the judgment is wrong. That's why we are on appeal. Now, the learned single judge of this honorable court wanted to call out a distinction between, my lord, misconduct at two different stages. And while doing so, learned single judge made an attempt to give an answer by saying, when you commit something at the stage of entering into service, then it cannot be constituted as a misconduct.
Mr. Chaudhary and Mr. Kohli, if not today, on the next day,
Yes.
I will request both of you to address the court on this simple issue. For the moment, I am leaving aside the judgment of the learned single judge. Of course, the ratio will be binding in this court.
Certainly, my lord.
But on a slightly academic tangent, what I wanted to know is this protection of the principle of audi alteram partem. Is it correlatable to the misconduct, or is it correlatable to the proposed action to be taken vis-a-vis the stage in which the action is to be taken? Let me phrase it in another way. Whether the misconduct is before entering the service or after entering the service,
Whether natural justice will apply or not.
natural justice, would it be relatable to whether the misconduct is of this stage or whether before a person is thrown out of service?
Yes.
It may not be strictly applicable in this case, or maybe I don't know. If you are throwing out a person from service, 311 lays down certain conditions, and which is basically embodiment of principles of audi alteram partem. Now, maybe in certain situations, exceptions may be permissible, that will not go into it. But if you are asking someone, or if you are terminating the service of someone in whatever mode or manner, will you say that because his misconduct is prior to joining service, so we'll adopt one procedure, and because it is after joining service, we'll adopt another? Will the law admit, will the principles of audi alteram partem admit this kind of a distinction? That is where I would request both of you to.
Why not? It'll be an
This is a little bit of.
Yes, I think it will be exciting.
That is the whole, my lord, rationale. That is the underlying principle. The question which your lordship has formulated, that is the question. If that be so, my lord, then my lord, there cannot be any dispensing with the principle of natural justice. There cannot be. Otherwise, my lord, lordships will be, laying down a new criteria.
No, but at the same time, this is also true what Mr. Kohli is submitting, that with all this police report and other reports staring at the face of the, materials on record,
Correct.
face of the case, even if, for the sake of argument, even if this order is to be interfered with, will it not be a matter of useless formality? Absolute useless formality.
No, my lord.
Why?
No, my lord. No, my lord, the lordship will kindly see police report, charge sheet, these will have got legal connotations.
No,
there.
Mr. Chaudhary, your client was in probation.
Yes.
If you are not in probation, the dimensions of the arguments will be completely different.
No, my lord, merely because I am in probation, the contours of law will not change. It remains same, my lord. Only thing is, my lord.
Subject
only-
to what,
Yes.
I'm sorry to interrupt you, subject to what both of you may argue. These are areas where more debate, more discussion is possible and may be warranted. But while a person may be entitled to the protection of 311, Article 311, if he is in temporary service, perhaps the situation could be a little different in case of a probationer, where he may get protection only against an arbitrary action of the authorities, and not beyond that.
No, with all respect.
Just develop this
No,
argument.
all respect, with all
The
respect. that is-
protection perhaps would be against an arbitrary, an ipse dixi.
My lord, in my humble understanding of the law, a probationer's right is same as that of a regular employee. Only difference is, my lord, in case of a probationer, if a non-stigmatic order is passed following assessment of his performance, he is discharged from service, then that order stands on a different pedestal. Otherwise, why it is said, my lord, that when the moment the discharge or release is founded on an allegation, Article 311 will apply. Why is it said? That means,
No,
my lord,
no, because-
the moment, my lord, some allegation is the foundation of the order, then, my lord, Article 311 protection will apply only to
You're
probationer.
right. You're right, Mr. Chaudhary. We'll have to wind up now because Mr. Kohli, but just on a parting note for today.
Yes.
You see, if I remember Dipto Prakash Banerjee.
Dipti Prakash
Dipti
Banerjee.
Prakash Banerjee. The law has been enunciated there to a great extent. I think Purushottam Lal Dhingra has also been
Shakir, all that.
considered extension.
I think we'll have to go through all that.
In fact, my lord, Radhesham Gupta is a more exhaustive law than Dipti
That's
Prakash
correct,
Banerjee.
that's correct,
Same volume.
that's correct. But the idea appears to be that if you are casting an aspersion, a stigma on a person,
Yes.
you have to give him a scope to explain his stand.
Supposing you pass a very innocuous order.
Then what is your protection?
Then the protection is court will leave the veil. Now let's kindly see, forget about this case. There is an FIR. Well, a police complaint could be vague also. A police complaint could be premeditated also. With some intent also one can file and police can also
But
investigate.
is it not the
No, no.
law that if it is an innocuous order of
No, my lord, there
discharge,
is an answer.
the only
The
thing
Supreme
that
Court is
needs to be
saying-
seen is,
No, my lord, in Khatri's case, can I read that one
Okay.
small passage, my lord?
Let's do it.
No. Ek minute. The procedure to be followed.
Mr. Kohli, the plane will not leave without you.
No, Lordship, I don't want to exercise any of those rights. We live in very changed times.
Why?
Minimum 1.5 घंटा.
एक घंटा लगेगा.
एक दिन चल 2 घंटा लगा. I had to phone a police officer and said, if you want me to have tea with you, I'll come to your office.
No,
You don't have
that's
to block
what he
me
needs, of
for
course.
35 minutes.
No, the problem starts after 4:30. Now he can safely go. Because once offices will start closing.
Yes,
then
but
he will-
please don't book your return ticket next time.
Okay, Lordship.
We are not going to have it on a third day.
Okay, Lordship.
We have to get over.
Yes,
this.
Lordship. So would Lordship be looking at some dates?
Yes.
This side of the
It is in
vacation? Lordship? In June, I'm not available, Lordship.
No. I'm out of job, bhai.
What?
I'm out of job.
So this, I'm saying this side. I'm not saying June, I'm saying 30th.
Both of you agree on a date.
My lord will kindly have it in this month.
30th.
Aji ki date.
30th
30th
Tuesday.
is okay. Okay.
I was saying this month. I was
Huh?
saying not in
Oh,
June.
I thought June. Okay.
June तो हमें अच्छे नहीं.
No, my lord, it will be a dangerous proposition, my lord, because there is a police case file, nothing has happened, a man is dismissed. And then, my lord, will have to apply that principle to so many other branches of law and try to find out the rationale of permitting such a course of action. End of the day, my lord, these are on the realm of ifs and buts. It may be correct, may not be correct. Where the finality has come. That I managed, I got the job by paying bribe.
Mr. Kencharu, senior counsel assisted by Mr. J. Patwari, learned counsel for the Rich Petition, also had Mr. Aaron Kohli, learned senior additional AG Assam, assisted by.
Miss Nimisha Menon. Nimisha Menon.
Respondents, arguments have remained inconclusive today on the request of learned counsel for both this.
Lordship would be pleased to hold it as part heard.
Directed to be listed again on 30th of May 2023 as fixed part heard matter.
I had Lordship not booked my ticket till Lordship.
All right, have a safe flight.
Keep your obliged, Lordship.
Wait, Mr. Mayor. Look, can we pass over for the time being?
No time being now, at 3 o'clock, no time being, pass over for the day. As paid for by petitioner's counsel, pass over for the day. Yes.
Look, can we fix it there?
Date in June, 15th of June.
My lord, he is coming.
Take these books. Yes,
This lordship, this matter relates to dismissal from the service. And
we'll be able to finish it today.
lordship, no, it will take some time. A Gayon is appearing on the other end from the respondent side.
You can finish it or I'll start, but I'm not keeping it as parted. There is already so many matters parted. But you have urgency, I do agree. Who is appearing for the other side?
For the respondent, A Gayon lordship, one Oda Gayon is appearing on the respondent.
Where is it? She is not to be seen.
So I will call him lordship that.
Call her, let her come. Yes, next matter. What is this case about?
A penal order passed. Penal order passed after disciplinary proceeding. That is,
What is the penalty?
uh, reduction of 5 stages with cumulative effect. The penal order is at page 79, Your Lordship. Reduction of basic pay by 5 stages with cumulative effect.
Page 75.
79, Your Lordship.
Yes.
Penal order is reduction of basic pay by 5 stages with cumulative effect. That is written in bold, Your Lordship. This order of penalty has been passed by the general manager, Your Lordship, and disciplinary authority. But the initial charge sheet was issued by the chairman as disciplinary authority.
So what is the ground of challenge?
First ground is that the disciplinary authority, chairman cannot be disciplinary authority, Your Lordship. Moreover, when the disciplinary authority is general manager, Your Lordship, in our affidavit filed by the respondent, they have said that in 2013, the rules were amended by giving the power of disciplinary authority to the general manager. But even after that, the charge sheet was issued by the chairman. That is not proper, Your Lordship.
Charge sheet was, memorandum of charge was issued by the chairman.
Chairman, Your Lordship. That is at page,
Where is it? Which page?
that is at page 26, Your Lordship.
Which bank is this?
Yes. Government Vikas Bank, Your Lordship.
No, but why do you say it cannot be done? Why the chairman cannot give it?
Because according to the affidavit filed by the respondents, the power has been delegated to the general manager, Your Lordship. And when the power is delegated to the general manager, how can the chairman again, without any notification or whatever, can assume the charge of a disciplinary authority?
No, but there must be some service rules, some rules, regulations. Some
There are service rules, Your Lordship, but I'll refer to the service regulation of 2010, Assam Gramin Vikas Bank, officers and employees, service regulation 2010.
Do you have an extra copy, spare copy?
I'll just give you an extract of the rules, Your Lordship.
Mr. Datta, you are appearing for whom?
And for the bank,
Do you have an extra copy of the rule?
I'll provide.
At page 23, Your Lordship, on the third page of the printout, Your Lordship. On the third page, the printout, Your Lordship. That is the page number 23 of the book, Your Lordship, of Assam Gramin Vikas Bank. On the right hand side, I have put a mark, Your Lordship. Provided further that no order of in imposing any of the major penalties specified above shall be made except by an order in writing signed by the competent authority. And if Lordship comes to the page just above that, the second page,
Yes,
The definition of competent authority is given, your lordship. Competent authority means the chairman in respect of officers and general manager of officers and general manager in respect of employee. Because the petitioner is an officer, the competent authority in his case will be chairman, your lordship.
petitioner was serving as what?
As officer, management group, grade number 2, your lordship.
Scale two.
Scale.
Look, this particular regulation has been amended. Your lordship may see the amended part also. Now, your lordship will read the competent authority. Means chairman, my lord, your lordship, can you see this part? Now, your lordship will find competent authority means chairman in respect of officer scale 3, 4, 5. And general manager in respect of officer scale 1 and 2. Now, the present officer, he was scale 2. So obviously, my lord, the general manager is the competent authority. There is no vice at all. I don't know why he has advanced that.
No, but the penalty has been issued by,
Penalty, my lord, is by the GM, general manager. He is the competent person.
This one reads, your lordship, this has been amended in 2013.
That I have told you, lord.
That reads, your lordship, competent authority means the chairman in respect of officer and general manager in respect of employees.
That has been amended. Possibly my learned friend is not aware of that. That's why he is advancing that.
This is the one, your lordship.
That, I have referred that, but subsequently there is an amendment.
Mr. Sharma, there is an amendment. 2014, 30th of June, 2014.
That
And your order of penalty is 30th of September, 2015.
Yes.
So it says general manager and general manager has done it.
Therefore, my lord, that argument will not hold good. We do not take your lordship's time and nothing on that point.
What do you say, Mr. Sharma?
that amendment part, I was not aware of, your lordship.
Have a look. You should not be taken by surprise. Have a look.
This was amended on 30/6/2014, your lordship. But the charge memo was issued on
No, charge memo, no, penalty, order of penalty.
order penalty was.
That is in 2015.
Order penalty was later, yeah.
Acceptable.
But then it started with the charge memo, your lordship.
Oh, but that was never challenged. He is the appointing authority chairman.
Lordship.
Appointing authority can be disciplinary authority. There is no
That is right.
difficulties. Then
Now, if your lordship comes to the allegations, your lordship, these are not definite, your lordship. Charges are not definite and distinct, your lordship. That is my second point, your lordship.
which page?
Is 26, your lordship. It starts from 26. Runs into 3 pages.
Which one is not definite?
Actually, none of them are definite.
So let us read
Because-
number 1.
Number 1, you have sanctioned 41 numbers of empty loans and so and so. Under capital subsidy scheme of NABARD, several serious irregularities were observed and committed by you in disposal of these cases. The irregularities are Roman 1, your lordship, small Roman 1. In sanction of these loans, you have made deviation in respect of loan component vis-a-vis the subsidy and margin money component. But you have sanctioned loan up to 2 lakhs. In irregular manner, I am skipping some lines, your lordship. This was done to avoid deposit of collateral security by the borrowers. This was actually done, Your Lordship, to lower the risk of the bank in reducing the quantum of the loan, so that, and by
But you have submitted your reply.
Lordship, I submitted my reply.
Have you stated that the charges were not definite and therefore it has prejudiced you?
He has admitted that. He has admitted. There's apology for that.
However, Your Lordship, the loan, sanction of the loans that have been referred with some irregularities, the person concerned, although maybe there are some irregularities in respect of deducting premiums of the loans granted to the parties from the borrower's account. That was done to safeguard the interest of the bank, Your Lordship. In fact, he was serving the interest of the bank rather than trying to default any money of the bank, or so that the public money that has been lent out by the bank gets safeguarded, Your Lordship. That is why the penalty imposed, major penalty of 5 stages, that is extremely harsh, Your Lordship.
But he has admitted that in one case he has done irregularities.
That irregularity is to safeguard the interest of the bank. That has also been stated by him, Your Lordship. That is not for his, he has not defaulted money, or he has
What is
not.
his admission? Let us see. Page number?
33, Your Lordship. Paragraph 2, Your Lordship. I acknowledge my fault in debit of marginal deposit account for an amount of rupees 4,10,000 to pay insurance premium to Bajaj Alliance Life Insurance Company. Being over enthusiastic to show good performance in bancassurance, that is the insurance policy, and succumb to undue pressure from the regional manager Balik. Balik is the insurance company's scheme, Your Lordship. I mistook my judgment and put to use the wicked plan, because opening of loan accounts were not completed by the last date. However, promptly the next day I have adjusted the amount through disbursement of loans. In this connection, I'd like to share my views that due to constant promotion of Balik, the scheme, through sponsoring of review meetings and giving unlimited access to personal mobile phones, they create undue pressure on us to enhance business. Numerous incentives, prizes offered by Balik and endorsed by Bank Authority induce me to take a shortcut to achieve the set target. So therefore, to achieve the target and to derive the benefit of the scheme sponsored by the insurance company, the action was done, and the insurance premium was deducted from the loan account of the. It is in fact, banking practice, Your Lordship, when a loan is granted, the insurance premiums are generally deducted from the borrower account. In my personal account also, when I took a house loan, I am setting an example only. When I took a house loan, house building loan, the insurance premium was deducted from my account. That is the practice of the bank, Your Lordship. So in fact, although it may be termed as irregular, but there was no assessment. It is not a misdemeanor or misconduct, Your Lordship.
And where are the findings of the inquiry officer? Where is the inquiry report?
That is at page.
Inquiry report at page 70.
70.
70.
It starts from 71, Your Lordship.
Finding you know. Start from page 63.
So where is the finding that the charge is proved?
It starts from page 71, Your Lordship. Down below, analysis of charges by you.
The Lordship will find it page
72, it's
70.
71.
Down below 72, down below your Lordship will find. There's chart number 1 to level against CSO by chart sheet.
On the top is the charge number 111. The argument of CSO is at page 71. The analysis says, second part of the analysis. The argument of CSO is not based on fact because
So 1, 2, 1, 1, everything has been proved. 1, 1, 1, 2, 1, 3, 1, 4. All the charges have been proved.
No, all the charges.
But the proper analysis was not done, Your Lordship, because the objective of issuing the loans or sanctioning the loans and the
So was there any loss caused to the bank? Any findings?
Obviously, my lord, the bank has been exposed to, my lord, your Lordship will find, the report also it is given. My lord, the bank account has become dormant, there is no recovery at all. Now, my lord, it's to look at even otherwise, your Lordship will find. There is so many discussion of this honorable court and of the apex court. Whether bank incurred any loss or not, this is not the issue. Even if there is no loss, my lord, misconduct has been committed. Therefore, my lord, because of his misconduct, simply because if the loss is not incurred, that will not obliterate his misconduct. Now, the confidence of the bank has been shattered.
So, Mr. Sharma, you know the principles. Where is the scope for a read court to interfere in this matter? Charges have been proved. The
Lordship, the inquiry report has never said there was a misconduct, Your Lordship. Only irregularities. And for irregularity.
that is inferred. If you conduct yourself in a manner which is found by the bank to be irregular and resulting into loss to the bank, is that not misconduct?
That must be pronounced, Your Lordship, because unless it is pronounced misconduct.
Penalty has been already imposed.
Yes,
The order of penalty has been implemented.
already implemented.
Yes, Your Lordship, he has already retired, Your Lordship, on 30th of April here. This
So it will have an effect on his pension also. Is he
Yes,
getting
yes.
pension?
Yes,
5 stages, Your Lordship.
the charges are very serious in the sense, your Lordship will find. The sponsoring authority has not approved the loan. Before that, my lord, he has granted the loan. But in all the cases, the charges is like this.
That is not the factual position, your
This is the factual position that has been established, and if you say that it is not the factual position, that will not do. If my learned friend can show that there was, the allegations were not proved at all, he has a case. But then if your lordship look at the allegations and the inquiry report, it is emphatically clear in every stage he has committed mistake.
Yes, Mr. Sharma, are you prepared? You're not answering the questions of the court.
Lordship, at least on the quantum of punishment, your lordship.
No, how, show me the way out, where is the principle?
That is what I am
It cannot be
finding.
done arbitrarily.
Fact, my lord. It was
There are
the
4 or
case-
5 charges brought against you, all have been proved. There is nothing to show that these are perverse. Then why a major penalty should not be sustained?
Penalty is in a lenient manner, my lord. It was a case of removal. But the bank has given
Yes.
some. difference.
Looks like. Mr. Sharma,
Lordship,
so I think let me dictate the order.
your lordship may certainly interfere in case of the penalty, your lordship, quantum of penalty. I have a citation, your lordship, but I am not finding it out. Maybe I have lost it somewhere.
Which citation you want? You tell me, I'll give you.
On
Which
the
one?
on the quantum of
Quantum.
quantum.
What is the principle on quantum? Shockingly disproportionate.
Lordship, that is it.
Huh? So how is it shockingly disproportionate?
Because of some irregularity, your lordship, because the money was it is here, your lordship.
Even in order to consider whether it can be punishment can be reduced or not, is not by this honorable court. It
That's
can
what I'm
also be-
telling him. That cannot be. You have to show that it is shockingly disproportionate. Otherwise, punishment cannot be interfered with.
Here it is a lordship, paragraph 22 in 2021-5 SSC 662, your lordship. Paragraph 22. May I read, your lordship? The question is whether the tribunal proceeded correctly in passing the final direction to impose appropriate minor penalty. The tribunal itself did not impose punishment, but left it to the authority concerned for appropriate course of action. It was of the view that considering the findings of procedural lapses against the respondent, the appropriate punishment could only be a minor penalty and not a major penalty. With this again, we are in agreement with the course of action adopted. The nature of charges found against the respondent can hardly be one to call for a major penalty, keeping in mind that there was no bribery charge. Anyone can make mistakes. The consequences of mistakes should not be unduly harsh. We are thus of the view that the direction of the tribunal is what is liable to be sustained. So a minor penalty may be imposed, Your Lordship. That is,
Yes. So charge number 1, Roman 2 has been admitted.
that to Your Lordship, not for defalcation of money, Your Lordship. It was done in an irregular manner to safeguard the interest of the bank money, Your Lordship, for ensuring the loan amount, Your Lordship.
So have you filed any appeal before the authority?
There was, Your Lordship, appeal file.
Where is the appeal? Let us see. Has he filed any appeal against the order of penalty?
In the writ petition, they haven't.
That I am not sure, Your Lordship. That I am not sure.
Is there any provision for filing appeal?
Yes, provision is there. But the regulation that.
Then you file an appeal, we'll ask the chairman to dispose of it with a reasoned order within
I
3
think
months.
Your Lordship can interfere on the quantum of punishment, Your Lordship.
Only on that you prefer an appeal. Punishment is too harsh, on that you prefer an appeal.
At this stage, Your Lordship can.
No, we will not. There is no, you have not made out a case. Is the same chairman still the chairman or new person has come?
Now the different person.
Take your chance. And then if you are still agree, you have not made out a case for interference. Read court cannot just do things arbitrarily.
There is a
No, the
There is a-
punishment can be
there is a court judgment, Your Lordship, that on the quantum of punishment, the court can interfere.
It can, but it has to be disproportionate to the charge.
It is disproportionate, Your Lordship, because
How is it? You have not argued on that.
I have only, if there were some errors of judgment in sanctioning a loan, these are some irregularities only, not misconduct, Your Lordship, because the money was not taken for his own personal interest, no defalcation of money, no aggrandizement, no misappropriation of funds, Your Lordship. Only the scheme of the insurance company were implemented within the time limit, and in a hurried manner it was to be done because there was a last date fixed for disbursement of the loans, and that was done hurriedly, and the money was paid to the borrowers, and there was no defalcation of money, nothing of the sort.
So there was no recovery of the loan. The process of loan recovery also suffered because of the irregularities.
Not because of that, Your Lordship.
No, my learned friend is only in one chart. Lord, another chart is there. This is your lordship will find that Kisan credit card which is given to the agriculturist. Now, what the officer has done, he has given loan to the tea cultivators for the tea garden laborers.
They do not have any sort of interest in this cultivation. They have taken the money and swallowed that. This is one chart which has been proved. Then another is what he has done. He has given loan to the piggery farmers. Now, that the sponsoring authority has sponsored on 14/2012. Before sponsorship, he has given the loan. Now, what so much interest he has? Now, definitely he has some monetary interest in it. Otherwise, why he should be so much in a hurry? Now, in all these things, my lord, and another striking thing you also will find, assistant manager, who is the another person who has to be consulted for pre-sanction, post-sanction. Now, he hasn't taken any pre-sanction, post-sanction from that officer.
All right, Mr. Sharma, for you, I'll dictate the judgment day after tomorrow. Whatever you want to do, you do it between that. Heard Mr. A. Sharma, and counsel for the writ petitioner, also heard Mr. S. Dr. Leonard, senior counsel, assisted by Mr.
K. Pomannu.
K. Pomannu, and counsel appearing for the respondent bank. On the request of Mr. Sharma, this matter is directed to be listed again day after tomorrow, that is 18th. For further hearing as of.
Next week, Your Lordship, next Monday.
Right, next Monday, 22. As a fixed part of the matter.
Obliged.
Obliged.
Achha, what about those two cases? When were those fixed? That-
Can it be on the 15th June, Lordship?
As paid for by Leonard counsel for both the sides, this case for hearing again on 15th of June 2023. Yes.
Much.
Item 13.
When? Only question is which date?
My lord. So essentially the issues are long, my lord. I can actually try to reduce it in 1 minute, my lord. But essentially we had prayed for is a cadre review, my lord. Since last 20 years, there have been no cadre review. The Home Ministry is the competent authority. We had submitted representations to the Home Secretary. Now affidavit now has been filed, not by the Home Secretary, but then Assam Rifles have filed. The Home Ministry is yet to consider our representation, my lord. If it can be closed in that line is one way we can go, or otherwise we have to, my lord, wait for the Home Minister's affidavit, my lord. And including DOPT.
They are the officers under the Assam Rifles.
Cadre review of cadre is.
Of Assam Rifles Group A officers.
But directly submitted to the ministry. Directly submitted to the ministry, but bypassing the provision of the Assam Rifles.
So why don't you submit another representative through proper channel? We'll ask them to consider.
Directly.
No, this was through proper channel only. He says it's not.
Says my lord.
It
In
is-
similar circumstances, my lord,
Huh?
honorable.
Yes.
Honorable. High Court of Manipur. Person order is stating that it is the rank of structure of various CPO because are governed by the respective act cannot be altered without the corresponding amendment of the act. Besides, even the Ministry of Home Affairs by office member. Stated that Assam efforts may continue to use the nomenclature or the non-gazetted schedule of the Assam Rifles equivalent to the to constable. A constable, inspector, as such, the plea of petitioner that they be appointed to the post of night, which has been merged with the head constable and where also.
Cadre restructuring is a policy decision, is a policy matter.
Policy decision, my
How
lord.
can the High Court say anything about it?
No, cadre review, my lord, essentially, there is stagnations, my lord, and there are other CPOs, my lord, had also approached. In those cases, my lord, petitions have been allowed. Then yes, essentially it is a decision to be taken by the government. But then in this respect, my lord, there is already a Rajya Sabha committee report also. Based on that, we had phrased the representation. Our prayer therefore was that It should be considered, my lord. We cannot say that essentially that these benefits have to be given to us. But then some exercise has to be carried out. DOPT time and again says that cadre review, there is a procedure of
You
cadre
must
review.
say something that you will consider or
Yes.
not consider, say something.
My lord.
You
Periodic
can't say
cadre
that I
review is
don't know.
required otherwise.
You are appearing the home ministry for the home ministry.
Yes, my
What
lord.
is your stand? You will consider or you will not consider their representation?
No, my lord, I have, they are pair, my lord.
Mr. Datta, they have submitted a representation. Either you will have to consider it or you will have to reject it.
Is up, we are before the ministry, my lord, consideration. The polishing matter, my lord.
You are the ministry today. You are representing the ministry.
because,
We are asking you, what will you do? What have you done? What have you done to the representation?
my lord, representation not submitted to us. They directly submitted to the ministry, my lord.
You are not appearing for the home ministry.
Yes, except that representation, no representation has been received by the.
Let this matter be listed again after 2 weeks by reflecting the name of Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India in the cause list as the counsel for the respondents. You are not giving answers to the question. We'll get the DSG and see what happens. He is not responding.
Date if possible, my lord.
After 2 weeks,
Well.
it's fixed, I think.
My lord.
That's all.